The the Senate Judiciary Committee will come to order. The clerk will call the roll. Okay, thank you. The first item is going to be Shannon Hurd, who's going to present to us recommendations by the Supreme Court for retired judges to be placed on recall whenever they need a retired judge to be recalled. Shannon Hurd, you have the floor.
Thank you, Senator Edwards. There was a list that was sent to each one of you. It contains, I believe, hold on just a second. I apologize. I have two feeds going.
Nine judges, retired judges?
Okay, 9 judges for the committee to vote on to find qualified. If any member wishes to remove someone from the block, they can do so as well.
Okay, I'll read them. The First Judicial Circuit retired judge is Randall D. Smith. The Second Judicial Circuit retired judge is Patricia L. West. The Third Judicial Circuit retired judge is William S. Moore, Jr. The Seventh Judicial Circuit retired judge is C. Peter Tench, T-N-C-H. The Ninth Judicial Circuit retired judge is Michael E. McGinty. The 13th Judicial Circuit retired judge is Joey Jeter Taylor. The 14th Judicial Circuit retired judge is James S. Yoffy, Y-O-F-F-Y. The 19th Judicial Circuit retired judge is Bruce D. White. And the 31st Judicial Circuit retired judge is Stephen S. Smith. These are the ones that have been recommended by the Supreme Court, the retired judges, to be available for recall. And so is there a motion that we adopt these, to certify these judges that I've just mentioned?
I so move.
It's been moved. Is there a second? It's been moved and seconded that these 9 retired judges be certified as qualified. All in favor of the motion, vote aye. All opposed, no.
Mr. Chairman, I apologize. It's just a voice vote.
Oh, I'm sorry. Okay. Well, we overdid it. We made it a, okay, all in favor, vote aye. Aye. All opposed, no. Motion carries unanimously. Okay, thank you, Shannon. We appreciate all your good hard work. Okay, that takes care of that issue. The next issue is the senators who are not on the committee. Senator Locke, is she here? 1138. And I believe Senator McClellan, you have a bill that's identical. Is that right?
No, we are
Oh, different judge. Okay. Senator Locke, 1138.
It's across the hall at General Law.
Okay. Senator Frivola, you here? Mason. Yeah, all right. Monty Mason. Senator Mason, Senate Bill 1272. And also 1431.
Yes, sir. Thank you, Mr. Chairman. If we could take 1272 first. Mr. Chairman, members of the committee, if you remember last year we did some work on unrestorably incompetent folks. This was brought to me in that same vein by the Virginia Criminal Justice Conference, and this is an effort. So you see on line 15, this is a defendant charged with capital murders deemed to be unrestorably incompetent. Right now, they're just kind of stuck in this perpetual cycle that is what we're always trying to do in mental health, and that's restorative. Well, these folks are generally deemed to have been unrestorably incompetent. So you see, we on line 17 may commit such defendants to the custody of DVHDS if they've been deemed or remained unrestorably incompetent for a period of 5 years. We then lay out that they can make interfacility transfers, treatment and management decisions. If there are any recommended changes to the defendant's course of treatment, line 26, they'll be notified, and the court will hold a hearing to determine whether the recommendation is authorized, and then they delegate any duties to someone who may be in day-to-day operations at the hospital. And so this is kind of an effort, Mr. Chairman, members of the committee, to keep this handful of capital defendants from just completely revolving around, can we restore them? I believe in the room I have both a defense attorney and a Commonwealth attorney who would like to address the group.
Okay, anybody, any questions of the patron?
Mr. Chair.
Mr. Chairman. Yeah, Senator Deeds.
I would either like staff or the patron to address whether we should allow the unrestorably incompetent to at some point have an independent evaluation done.
Is there somebody to answer those questions?
Well, Mr. Chairman, I would point to him that, and I mean that this does not address, but this is provided the defendant has remained unrestorably incompetent for a period of 5 years. So I read that to mean they're having ongoing evaluations, but that doesn't necessarily mean it to be so. So if we want to spell that out, Senator Deeds and Mr. Chairman, I think it makes sense.
Okay. Is there staff would like to? Charles, does somebody explain this? Charles?
I've got Mr. Chairman, I have a question.
Let's see if you can
Mr. Chair, I would say I think that question might be better for the prosecutor and defense attorney, who I think will be talking about this bill.
Okay.
I know this product, the bill came from the Virginia Criminal Justice Conference. And, from what I understand, there's basically 2 or 3 defendants who this bill will probably apply to. And I think their each individual case is rather unique. So I think their question might be better, Senator Deeds' question might be better answered by them as to what they would think, because this is a kind of a bill that everyone kind of agreed together. So I defer to them as to whether or not they think there should be.
Okay. Is there a prosecutor or defense attorney explain, one of you?
Could you please repeat the question? I apologize. I didn't hear the question.
My question was whether or not there should be some right in somewhere in the process for this unrestorably incompetent person to at some point request an independent evaluation. Have somebody from outside of the system take a look at him and make some determination of whether or not they're competent.
Okay. Anybody want to answer the question? Do you understand the question?
Mr. Chair.
You go ahead. Who would like to
My
do it?
experience in representing
your name is, go ahead, say.
Pardon me.
Say-
This is Andrea Mosley. I'm a defense attorney in Alexandria, Virginia. Mr. Green and I co-chaired the committee together, putting forward this bill 1272. Over a couple of years, we worked on this, and we were not trying to address how the person was actually found unrestorable. This is once a person has been unrestorable for 5 years, how we might open up the opportunity for further treatment. So we were not addressing how they would independently or not independently be evaluated before they get to this place. But my experience.
Go ahead, Senator Deeds.
Would they at some point be able to go to the court and ask for an independent evaluation? I'm just interested in trying to figure out whether there's somebody outside of the state employment who might be able to take a look at this and figure out how to get this guy tried or into treatment.
So the person that I represent was independently evaluated. We simply asked the court to do so. They appointed someone from the University of Virginia who was qualified and then made that report. It wasn't hard to do.
So I guess the
Mr.
answer
Chair?
is yes. Senator Morsi, is that right?
Thank you. Yes. To the patron. Senator Mason, on line 16, it says the court may commit such defendant to the inpatient custody of the commissioner of DBHDS. What exactly does that mean? Are you talking about a St. Elizabeth's type custody or some other DOC facility?
Mr. Chairman, Senator Morrissey, I would think that also would include Eastern State and one of our state-run mental facilities.
Okay. You're
Any other
specifically.
questions?
I'm sorry. One final question.
Senator Morsi.
You're not including any DOC facility in that. Is that correct?
Mr. Chairman, Senator Morrissey, I do not believe they would come under the commissioner of DBHDS. So this is for state-run mental hospitals.
Okay. Anybody else have any questions? Is anybody else like to speak for or against the bill? You got 2 defense attorneys who want the bill. Is that right? Somebody says you had a prosecutor, Monty?
Mr. Chairman, this is Nathan Green, Commonwealth's attorney for the city of Williamsburg and James City County. I'm also a member of VCJC and worked with Ms. Mosley on this bill. So we have two attorneys, one defense attorney, one prosecutor. I don't think we have two defense attorneys. I just wanted to clarify that.
All right, is there any
But-
opposition to the bill?
Mr. Chairman, I have one quick question.
Yeah, Senator, who's that?
Sturvell.
Sturvell, okay, go ahead.
I mean, in light of the bill that we passed last week that that would get rid of capital punishment, I'm just curious whether there's any changes that would be made to this to make it consistent, or whether that gets handled by the code commissioner or somebody if this ends up passing, or the governor, or what?
Well, this doesn't necessarily deal with death penalty.
Deals with capital defendants,
Well,
Mr.
okay,
Chairman.
yeah, but other defendants as well, right?
No, it's only capital
Mr.
defendants, Mr. Chairman.
Okay, all right, okay.
Mr. Chairman, again, this is Nathan Green. I do believe that Mr. Survell's question, or Senator Survell's question, is appropriate. In line 15, it does say when a defendant charged with capital murder. I believe you are changing the language of that offense, and I do believe that code compliance would just change that along with it.
Okay.
Would you like to make it if a person's charged with murder?
No.
No.
No. No.
Mr. Chair, I think what he's saying is that the code commission will fix any problem.
Yeah, well, I'll chair the code commission, we'll fix it. Okay, is there a motion? The move that it be reported, Senator Dees seconds the motion. All in favor of the motion, vote aye. Aye. All opposed, no. Okay, thank you, Senator Mason.
One more, Mr. Chairman.
It's 14-0.
14
We
to
have a quorum
0.
of one.
I'm sorry, what? 14 to 0, is that right? Yeah. Okay, the bill passes.
Thank you, Mr. Chairman.
The bill is reported, okay.
One more in the
Senator
same
Mason.
vein, Mr. Chairman, Senate Bill 1431.
1431.
This was not brought by the two folks so we kept it separate and distinct. But this was brought to me, actually, by a judge who runs one of our mental health dockets. And last year, we changed the unrestorably incompetent. If you had dementia or you had Alzheimer's, and it was well stated. This is charge specific. So if we have someone comes that's unrestorably incompetent, and they're found that way, moved along, and then 6 months later they come back with a different charge, we have to go through the whole process again. So he had suggested on line 49 of this bill, or if the defendant was previously determined unrestorably incompetent in the past 2 years. So that is if it had been determined by a court or by the groups that we added last year able to do so within the last 2 years, you didn't have to go through the whole process again.
So,
Yeah, Senator Deeds.
the way this, if the person has a problem a year after, he doesn't have to go through doesn't have to be reevaluated. He's just uncontrollably incompetent.
Mr. Chairman, Senator Deeds, a 2-year window. Yes, sir.
So the whole idea here is to create some efficiency of the evaluations cost money and they take time. You're only doing one every 2 years, no matter how many times you get in trouble.
Yep, Mr. Chairman, Senator Deeds, and this judge had seen the same person, been through the same situation, knew the circumstances, and had to do the same process again, and that's what he was trying to address.
Okay.
Is there anybody want to speak for or against the bill? Is there a motion? No. Is there somebody in the public who'd like to say something? No.
I don't believe so.
Okay.
At this time, Mr. Chair, there are no hands raised.
Okay, is there a motion? Moved and seconded by Senator Deeds to report the bill, Senate Bill 1431. All in favor, vote aye. All opposed, vote no.
Okay, that's 2 bills. That means we have to take one of them back.
It's 14-0.
All right, Senator Mason, you're batting 14 to 0 today.
Thank you, Mr. Chairman, members of the committee. I appreciate your
Thank you very much. Senator Locke, Senate Bill 1138. Senator Locke here? Okay.
Long days, baby.
Senate Bill 1138. Great bill. Okay, Senator Locke.
Thank you, Mr. Chairman. Senate Bill 1138 aims to repeal and amend several provisions of the Virginia Code to reflect the current scientific understanding of HIV, limit the scope of the law to prevent criminalization of people living with HIV who engage in consensual sexual activity. This bill removes the ability to violate the human rights of individuals living with HIV and promotes public health by alleviating the stigma and mistrust of health institutions that contribute to barriers limiting usage of testing and treatments. Essentially, what SB 1138 does is it makes four main changes to various Virginia statutory provisions. First, it repeals the HIV criminalization statute. It repeals adjacent testing provisions. It repeals tissue, body fluids, blood, and organ donation and sale ban. And four, it modernizes mandatory testing provisions for people charged with drug use and prostitution. And that's what the bill does.
Okay, any questions of the patron? Anybody would like to speak for the bill or against the bill? Anybody from the public?
Mr. Chair, we have several members.
Okay.
Would those who are in the Zoom call, if they are in favor, please use the Zoom feature, raise your hand. Deirdre Johnson, please go ahead.
Unmute myself. Thank you so much, Chairman Edwards and members of the Senate Committee on the Judiciary. Thank you so much. My name is Deirdre Johnson, and I'm the co-founder of Ending Criminalization of HIV in Incarceration in Virginia, or ECHO Virginia Coalition. I come to you today to ask you to support Senate Bill 1138. The bill ensures that Virginia Code reflects the current scientific understanding of HIV and promotes public health by alleviating the stigma and mistrust of health institutions that limit the use of testing and treatment. I received my HIV diagnosis in 2000 while 3 months pregnant in Texas, where there are not any HIV criminalization laws. Upon my return to Virginia 3 months later, I was informed that engaging in sexual activities while living with HIV was considered a misdemeanor. But after researching HIV criminalization laws, I saw that the laws do not exist for other communicable diseases. So I question, why is only my status singled out in the law? Even in 2001, it was communicated to me to make sure that I continued to take my medication and not giving the HIV to my unborn child, who is now 19 and was born HIV negative, or to my future partners. We now know that the scientific information has advanced to what we know is now as undetectable equals untransmittable. This means that if you have an undetectable HIV status, then I am now at a zero risk for transmitting HIV to my partners. Thus, the infected sexual battery law in Virginia does not make sense to me. Care and treatment services are well advanced with appropriate options to get people living with HIV to an undetectable viral load. Virginia's HIV criminalization law are rooted in stigma and discrimination. It targets people living with HIV specifically, painting them and people like me that look like me to be viewed as vectors of disease and to be feared and criminalized. I am not anyone that you should fear. HIV criminalization is a racial justice issue, and these laws have been disproportionately used against Black, Latinx, Indigenous, and other communities of colors and communities also significantly impacted by HIV. HIV criminalization laws like the Commonwealth's sexual infected battery law only serve to further criminalize marginalized communities and exacerbate medical mistrust. I thank you today for taking the time to hear my public comment in full support of SB 1138. It is important that the Commonwealth of Virginia does its part alongside and in partnership with the National Ending the HIV Epidemic Initiative, and the Senate bill is vitally important and a huge milestone in ending the HIV epidemic within the Commonwealth. Okay. Continue to stay healthy and safe and keep up the great work for Virginians. Okay. Thank you so much for your time.
Thank you very much. We have 3 other speakers from the public there.
Once more, would those who are in support of the bill please raise their hand in Zoom using the Zoom feature?
And I'm going to give each one 1 minute, 60 seconds.
V. Lamnick, go ahead.
Good afternoon, Mr. Chair, members of the committee. My name is V. Lamnick. I'm the Executive Director of Equality Virginia. We're the Commonwealth's leading organization advocating for equality for lesbian, gay, bisexual, and transgender Virginians. And we support Senate Bill 1138. In the last 30 years, what we know about HIV and its transmission has drastically changed. Through research and medical advancements, it's now possible to treat and reduce a person's viral load to the point where transmission no longer occurs. While these advancements have greatly improved the quality of life for people living with HIV, unfortunately, our legal code has not caught up. Current Virginia law criminalizes people living with HIV. The current statute is the only one in Virginia that makes it a crime to live with a treatable disease and is disproportionately enforced by against people who are already heavily policed, including Black and brown LGBTQ people. The stigma, fear, and mistrust that this law perpetuates contributes to extremely negative public health outcomes, as many people avoid the healthcare system and purposely refrain from getting tested in order to reduce the risk of interacting with law enforcement and the potential.
Yeah, thank you. Thank you very much. And I wish we had more time, but there are two other people, is that right, who speak in favor? Yeah, go ahead.
Clay Porter, please go ahead.
Hello, can everyone hear me?
Yeah. Go ahead, 60 seconds.
My name is Clay Porter, and I'm a member of the Virginia Community Health Planning Group and a student at Eastern Virginia Medical School who is also living with HIV. I've been working in HIV prevention for about 10 years, and my experience with the HIV criminalization laws in Virginia, both personally and professionally, have afforded me a unique insight into how they undermine public health efforts. SB 1138 answers the call to action by CDC and Department of Justice to align HIV laws in Virginia with our current scientific understanding. Your predecessors added this code to protect the health of Virginians. We now understand these laws work to counter the culture of normalizing HIV and STD testing to quickly find and treat new cases and avoid the spread of disease.
Okay, thank you very much. Is anybody against the bill? Anybody?
Would those who oppose the bill please once again use the Zoom feature, raise hand?
Okay, looks like it's in good shape. Is there a motion?
Mr. Chair?
Yeah, Senator Cyril.
Peterson.
I'm Peterson.
Sarvel.
Looks just like.
Sarvel.
Peterson.
Yeah, I have a question on 196, and this is a question for staff, I guess. Lines 196 through lines 210 talk about, I guess it's a positive test for hepatitis C, and what the state health commissioner is supposed to share that information when there's a positive test for hepatitis C. Is that supposed to be part of this bill? Why is that part of this bill? I asked a compound question.
Somebody want to answer the question? Charles?
Mr. Chair, so to answer Senator Peterson's question, lines 196 to 203 do with a diagnosis for hepatitis C. And I believe the intent of the bill was to eliminate all references to communicable diseases, not purely HIV. So that is why hepatitis C appears. Hepatitis C is known to be a sexually transmitted infection, and that's why I believe the language struck.
Further question, Mr. Chair?
Senator Peterson.
Yeah, and I just heard some of the witnesses saying what the intents were of this legislation and how it was supposed to sort of stigmatize certain communities. Actually, I believe I remember this bill. It wasn't that long ago where if somebody was diagnosed with hepatitis C, we were going to reach out to law enforcement or whoever had come into contact with that individual in order to make sure that they were protected. So I'm not quite sure why this has gotten pulled in, because again, I don't think this law is that old that we're looking at right now. I feel like it was only passed 2 or 3 years ago, but maybe I'm mistaken.
Mr. Chair.
Okay.
And Mr. Chair, from what I understand, the treatments of hepatitis C have advanced so much in recent years that hepatitis C has now become a treatable infection. And I can't remember which commercial it is, but essentially you can take medicine for hepatitis C now that can essentially cure you of hepatitis C. So I think that was also part of the intent here, was since hepatitis C is no longer a lifetime ailment, which it may have been a few years ago, that is why it's been stripped out. But Senator Peterson may be correct in that the addition may only be a few years old in the code.
All right, my final question, I think Senator McClellan wanted to speak also, but
go ahead,
I just want to be sure that the sheriffs are okay with this, and because I do feel like this is a fairly recent effort, at least on the Hep C side. I do remember those bills, but I just want to make sure that the sheriffs and law enforcement and first responders, for that matter, signed off on that.
Okay, there's a couple other people who want to speak for the bill. Is that right?
Well, Mr.
Mr. Chair, if I,
Yeah, you go ahead. Senator McClellan.
yeah, if I may help here, I'm the co-chief patron of the bill, and the idea behind this whole bill is when the HIV portion of the code was put in, and then the hepatitis C added later, it was put in the criminal code in part because of 30 years ago what everybody thought was the science around HIV as being not curable, not treatable, a death sentence. It was actually put in as part of some requirements to get federal funding for Ryan White funds, and those requirements have gone away. Since then, the CDC and the Department of Justice and the U.S. Department of Health and Human Services have recommended that these criminal statutes be eliminated because they have actually had the opposite effect on public health. When people are afraid that they may end up putting a target on their back for criminal prosecution, they don't get tested and they don't get treated. And there's lots of studies that show that. And so to the extent you want to have information about a diagnosis transmitted, that is better dealt with in the public health code, not in the criminal code.
Okay. Now, Senator Lucas, would you like to say something? Senator Lucas? Senator Peake?
Yes, thank you. First, I had a question, and I want to speak to the bill. My question would be to either the patron or staff. Does anybody know how many people have been charged under this statute in the last 2 years?
Anybody know the answer to that? Apparently not.
Okay, and then my comment would be, if you look at this statute, at lines 160, any person who possesses with the intent thereby to injure another. And then if you go down to line 167, any person who maliciously and intentionally causes any other person bodily injury by means of this. So they have to know it, and they have to intend to injure someone. This is not a statute that's meant to stigmatize anyone. I mean, we recall there were people out there knowing they had AIDS, going out and randomly, indiscriminately having sex with others. That's why we have this statute. The same with hepatitis C. This does not stigmatize anybody from getting treatment. It's a misdemeanor. But certainly when you're dealing, you call people spitting on people or scratching them or trying to do these things, certainly law enforcement. And we do not have any indication that this statute's been used against any number of people. I just don't see the need for it.
Mr.
Okay,
Chair.
Senator McClellan.
Yes, Mr. Chair, I would note that the section of the bill that Senator Peake referenced is not being changed by that bill. That is current law, and it will remain law after this bill passes. The sections that we are repealing deal specifically with a statute that basically makes it a crime to have sex with someone if you are HIV positive, and some associated testing criminal procedures.
Okay.
Whether the intent was to stigmatize or not, the effect has been that once people with HIV know they can be subject to criminal penalties, they don't get tested, they don't get diagnosed, and this is basically taking what is a now treatable disease that we understand more about how it is transmitted and how it is not in a way that we didn't understand when this statute was first put in place, that the CDC and the Department of Justice and the U.S. Department of Health and Human Services and 8 other states have recognized this statute is counterproductive to public health.
Okay, thank you.
Mr. Chair,
Senator,
just to answer.
Who's it? Yeah, Charles, go ahead.
Just to answer Senator Peake's question. In 2019 and 2020, according to the Virginia Sentencing Commission, 3 offenders were convicted of felony infected sexual battery and were convicted of the misdemeanor sexual battery offense. And to answer Senator Peterson's earlier question, the hepatitis C was added to the statute in 2005. I realize sometimes years seem to go by quicker than we think they do.
Okay. Senator Obenshain, you have a question?
Yeah, I do. And maybe I'm misreading this bill, but which is entirely possible, but it looks like it's repealing section 18.2-67.4:1. If you look at the very end of this, and that is the infected sexual battery provision. And contrary to what I've heard, Section A makes an existing law says that it is a Class 6 felony right now, not just to have sex with somebody if you have HIV or hepatitis B or syphilis, but it is an intent, a specific intent crime. So under existing law, if you have active syphilis and go have sex with the intent to transmit that syphilis, it is a Class 6 felony. Now, I can't figure out for the life of me why we would want to repeal that. I understand that just because you had an HIV diagnosis and you have aggressively treated it and have no detectable levels, I get that. But that's not what the repeal of this section does. This says if you've got active HIV, untreated HIV, and you go out with the intent to transmit the infection to another person, why would we want to repeal that?
Okay. Anybody want to answer that question? That there's a couple of people that still haven't had a chance to speak, I believe. Go ahead. Who would like to speak next? Who's on Zoom?
Can somebody answer that?
Well, Mr. Chair, I guess why would you only pick out 3 sexually transmitted diseases when they're and have a crime for those and not other sexually transmitted diseases?
Because it's existing law. I mean, I'm just asking why we'd want to repeal that.
Because you are treating these sexually transmitted diseases differently from other sexually transmitted diseases.
I think it's because you can die from them.
You can also die from the others.
Which one?
Gonorrhea.
Okay. But that's not in the statute. So, I mean, it would seem that the solution would be to add, not to make it legal to go out and transmit syphilis with the intent to transmit it. I mean, it's part of the other sections, B and C, and I can understand maybe why you, consistent with the argument that's been made, you may want to repeal those, but I'm having real problems with why we'd want to decriminalize the intentional transmission of HIV, syphilis, or hepatitis B to an unknowing sexual partner.
Charles, can you explain? Yeah, Senator McClellan, go ahead.
We actually have an expert from the CDC who can answer that question.
Okay, who's that? Who's the expert from the CDC? Somebody here?
Cedric speaking. Hello, can you hear me?
Yeah, go ahead.
So just to address some of the queries in regards to some of the senator's questions, one, in the different criminal proceedings that have occurred.
Mr. Chair, could he identify himself?
Yeah, you tell you.
All right.
Cedric, what's your name?
Cedric Pulliam.
And you work for the CDC?
I do, but I'm also the co-founder of Echo VA Coalition alongside Deidre Johnson, who spoke earlier.
Okay, go ahead.
Can I ask, is he here on behalf of the CDC?
I'm here on behalf of Echo VA Coalition and not the CDC.
Okay, go ahead and answer the question if you can.
So the answer to your question in regards to intentionality is that in the mere fact of this actual infected sexual battery law that was enacted in 1997 with iterations between the 2000s up until the latest, I believe the latest was in 2011. But this particular law, intentionality has not ever in most of the criminal proceedings even been proven. Like you do not even have to transmit the virus of HIV to the partner that has brought you to court to prosecute you under infected sexual battery law. And the fact of the matter is also, you have to realize that hepatitis B and syphilis, we don't have any historical record of those cases being actually criminally charged. Only HIV is the pinpointed one of the 3. And also, when you think of intent, intentionality, for the prosecution to prove intentionality, it's a he say, she said kind of situation. Whereas, where's the actual proof of that intentionality?
Okay.
When you think of an actual HIV transmission, and most of these cases that we have saw throughout 1997, the first case was tried in 2000 in Virginia. This law has been enacted since 1997, and I want the senators to recognize that this is beyond just a couple of years or a few years. It's been since 1997.
And I guess I would ask,
Overton,
consider the possibility that people know it's illegal.
Well,
They are actually educated, a health educator or a linkage educator in any health facility, clinic, or community-based organization or hospital
Mr.
will,
Chair.
when they provide diagnosis to a newly diagnosed HIV client, it is mandated by law that they discuss this particular law with them under the diagnosis appointment when they're linked into care.
Okay, Senator Deeds, you had a question?
Mr. Chair, in 1997, HIV was basically a death sentence. AIDS was his death sentence. The science has dramatically improved the diagnosis for HIV or AIDS, and it makes sense for us to look at changing the law. But I agree with Senator Obenchain that if someone intentionally infects someone else with a disease, that there ought to be some criminal penalty.
Mr. Chairman, it's
Steve.
It's Steve.
Steve Benjamin.
Yeah, I think the answer is that there's a difference between those cases where the defendant admits, yeah, I did it with the intent to transmit the disease. There, the intent is clearly known and established. I suspect that the concern is that intent can also be inferred from conduct, so that if someone who knows they have HIV has unprotected sex with someone, they could be arrested, and in fact, their intent to transmit it could be inferred simply from their act of having had unprotected sex. And I think that's the concern here.
Mr. Chairman?
Yeah, Senator Obenchain.
In that, Steve, I would ask, Steve, isn't that more likely to be prosecuted under Section B as a Class 1 misdemeanor?
Mr. Chairman, answering Senator Obenchain, it would be charged under subsection A in order to compel a guilty plea. Subsection B would be where you would go for a plea agreement to avoid a felony.
Okay. I think we understand it. There's a couple of other people that still haven't spoken. Is that right or not? Is anybody in the outer world want to say something that has not yet spoken?
I haven't spoken.
Tyler Barberin, please go ahead.
All right, go ahead. Your name?
Hi. Oh, somebody. Oh.
Yeah. Hi, Tyler Barberin here. Thank you, Chairman Edwards and members of the Judiciary Committee. I'm a policy associate with the Positive Women's Network USA, and I'm here to speak in support of Senate Bill 1138. PWN is the only nationwide membership organization comprised of women and people of transgender experience living with HIV. Our work is grounded in social justice and human rights, and we explicitly apply a racial justice and gender justice lens to address the multifarious barriers, including criminalization, that women and people of trans experience living with HIV face.
Okay.
Virginia's criminalization law works against public health and public interest. HIV criminalization laws disincentive HIV testing by subjecting those who know their status to the ever-present threat of arrest and criminal prosecution. They create mistrust of and alienation from public health institutions and put people living with HIV at heightened risk of violence from intimate partners, threatening to disclose and weaponize their status if they attempt to leave an unsafe and unhealthy relationship.
Okay. Thank you
The
so
law
much.
also.
Okay, thank you so much. Is there another person who wants to speak in favor of the bill?
Andre Lepart.
Okay. Leopard?
Andre Lepart, you're muted. Please unmute.
Can you hear me okay?
Go ahead.
Okay. Dear Chairman Edwards and members of the Senate Committee on the Judiciary, I'm writing today to ask that you support Bill 1138. This bill ensures that Virginia Code reflects the current scientific understanding of HIV and promote public health by alleviating the stigma and mistrust of health institutions that limit the linkage or usage of tests and treatment. I am an HIV positive Black male who was prosecuted under the sexual battery statute in 2017. This statute did not require scientific proof of HIV transmission. The only thing the plaintiff had to prove was non-disclosure. The status of undetectable versus detectable was irrelevant. After the pleading to a misdemeanor conviction of infectious sexual battery, I have become an activist and the founder and executive director of a community health nonprofit that focuses on HIV testing, outreach, and education.
Okay.
As a community health professional,
Okay, thank you.
clients who have been tested for HIV told me that they do not get tested due to the stigma and fear of prosecution.
Okay.
It is possible that the criminalization of HIV is discouraging people from getting tested and also driving up the infection rates in Virginia.
Okay, thank you so much. Does anybody want to speak against the bill? Is anybody against the bill? Is there a motion?
Mr. Chair, I've got a question.
Yeah, Senator Morsi. Is there a motion?
Yeah, no, I have a question.
Okay, go ahead.
All right. Two of our senators on this committee asked about the language, any person who maliciously and intentionally causes, and I don't think I heard the answer from any of the witnesses who testified, the patron, or any other senator. Is it, so I'm going to ask it again with specificity to the patron. Is it your intent, Senator, that if somebody maliciously, and that's not just a throwaway word, that is a word that has a lot of importance in the criminal code, who maliciously and intentionally causes any other person injury because of an infection, including HIV, is it the intent of this legislation to not have that person fall within the parameters of 18.2-52.1?
That is not the intent of this legislation.
Mr. Chair.
Yeah, Senator McClellan, she explained it once before. Senator McClellan, go ahead.
Thank you, Mr. Chair. It is my understanding that that Section 18.2-51 has also been used to prosecute in the intention with malicious intent to transmit a disease cases. So that is still a provision. And
I can't hear.
You would still have another, if someone had sex with someone with the intent to infect them with a disease that could cause their death.
It would be what?
It could be charged and has been charged and prosecuted under malicious wounding in 18.2-51.
Yeah.
That would still be available to a prosecutor in the fact pattern that both Senator Obenshain and Senator Morrissey just said.
Yeah.
Okay, follow-up question.
Go ahead, Senator Morrissey.
I believe Senator McClellan said that if somebody intentionally and maliciously infects somebody with HIV, that they could be prosecuted for malicious wounding. That's what you did say, Senator McClellan. Is that correct?
That's what she said.
That's what she said.
I said they have been charged and prosecuted under that in the past, so presumably they could continue to be in the future.
Okay.
But hold on.
Here's my question to Senator McClellan or to Senator Locke. Why are we removing it from this section if somebody, this has nothing to do with stigma or anything like that? I've got the greatest empathy for anybody with any disease, but tell me why succinctly, if they maliciously and intentionally transmit HIV, and that we would remove that from remove that behavior from this legislation. That's what I need to know.
Mr. Chair,
Senator McClellan, go ahead.
I would respond by saying when the HIV statute was put in place, it was put in place as a separate, specific crime because at the time it was believed that transmitting HIV to someone was in and of itself a death sentence.
I just can't.
It targeted HIV and has been since added to other diseases that at the time were a death sentence. But there are others. And so rather than you do stigmatize something when you highlight it for separate and specific criminal prosecution rather than using it in a more general statute that is still available for anyone who intentionally seeks to harm somebody.
Okay, thank you, Senator McClellan. I think it's been fairly clear. Anybody else see the need to speak? Is there a motion? I'm sorry, I can't hear you. Is there a motion?
Move to report.
Is there a second? It's been moved to report. Is there a second?
Second.
It's moved and seconded to report Senate Bill 1138.
Mr. Chair.
Go ahead, Senator Peterson.
I appreciate, and we spent a lot of time on this. I appreciate Senator Locke bringing this. I have a little bit of hesitation here, and by the way, some of the comments that were made, I take a little bit of exception to. I mean, for those of us that grew up when HIV/AIDS became sort of the pandemic of our generation, there were laws that were passed that were intended to protect people, and they weren't intended. Maybe they did, as a de facto matter, stigmatize people. But I take a little bit of exception to saying laws were passed to marginalize certain communities. I think we were trying to protect people and save lives. I'm not comfortable with just sort of throwing out the hepatitis C baby with the bathwater here, and so I'm going to abstain on this. I'd like to get some information. There's a lot of sheriffs out there who have dealt with outbreaks in jails, and this simply, again, put them on notice that if someone tests positive, they're given notice that person is in their institution. I think that makes sense. So I'm sure there's a lot of merit here, but I just think this bill may need a second look.
What about it? What's he want? What? I can't hear you. He wants to do what?
He wants you to
No,
your laptop. So he can pull it.
Okay, all right, fine. Yeah, you pull it up. All right, go ahead. I think we have a motion on the floor. I think I understand it quite well. Been explained quite well. All in favor of the motion to report the bill, vote aye. All opposed, vote no.
Ayes 7, noes 5, abstentions 2.
Okay, thank you, Senator Locke. Yeah, okay. 5, 7, 5, and 2. Okay, the next, what I want to announce that Senator Hashmi has Senate Bill 1340, but that is going by for the day. Is that right? Senator Hashmi's Bill 1340 will go by for the day. The next person is Senator Donovan. Is that right? Yes, 1325, Senator Donovan. Step right up.
Mr. Chairman and members of the committee, I am so happy to present to you today with a consensus bill, if you can believe that, on grandparent visitation.
That's what we like, consensus bills.
Yes. So we have a substitute, and we'll start with that so that you can get the substitute up. And I am very grateful to the Family Law Coalition and Dan Gray, who helped with this and met with many of the advocates from across the state. You all know the issue, and you know the challenges, and you know that Troxel is one of those challenges. The consensus that we have been able to reach is a small new language on 30 to 36. It basically says that grandparents can petition the court for visitation. I guess you have to move it.
Do we have a substitute?
Mr. Chairman, I'm posting it now.
All right, explain what the bill does.
I'm sorry, are you asking me or are you asking Senator Donovan?
Senator Donovan. Yeah, no.
I'm so sorry. Yes, sir, I didn't hear you.
Maybe either way. Go ahead.
It allows the court to consider evidence that would support a desire of a deceased or incapacitated parent for that grandparent to have a relationship with a child. So essentially, the example I've been given is if, the mother or father of children die, the court does not have the ability to infer consent from the deceased parent. at this time. Therefore, if the surviving mom objects to the visitation, a grandparent wishing for visitation has to prove actual harm, which we all know is a really high bar. If the grandparents, for example, could prove that their child would have wanted visitation, then you have a scenario where one parent wants visitation, the other doesn't. In this case, the grandparents need only to meet the best interests standard to get visitation. That was the consensus that was reached with the Family Law Coalition that they believe meets legal criteria. There's a little bit of a question about is hearsay a problem here? And it could be, but by allowing the courts to consider this and being able to provide evidence to support their assertion, it seems like it's a good compromise that pleases these grandparents that are struggling to have a relationship with their child. And finally, it does not include those that are incarcerated, which is something we had aspired to do in the bill last year, because those parents are still alive and they can provide a written intent. And if in fact a parent is sick and they know they're going to die, they can provide the grandparents also with a written intent so that they have that level of verification for the court going forward. I believe there are people who are much smarter than me on this issue that can speak to this bill. Mr. President, they're probably waiting to speak. Mr. Chairman.
Yeah, go ahead. Who would like to speak for the bill? Be nice if we could
Mr. Chairman,
get up to
they're
get to
coming
the
into the room
substitute.
now.
Is there a motion to adopt the substitute?
So moved.
Second. All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. The motion carries. Now we have the substitute, and it should be up on everybody's screen. Senate Bill 1325. Okay. And who would like to speak in favor of the bill?
Daniel Gray, please go ahead.
Yeah, go ahead. 3 minutes.
Thank you very much, Mr. Chairman and members of the committee, and thank you very much for Senator Donovan giving us the opportunity to address this issue. This is a consensus bill. As the law stands now, if both parents object to grandparent visitation, the grandparents have to prove actual harm. And if one of the parents is deceased, the court is not currently permitted to infer consent from the deceased parent. And what this bill does is permits the court to take evidence about whether that deceased parent would have consented to the visitation between the minor child and the grandparent. And if the grandparent can prove that the deceased parent would have consented, they are subject to a lower standard to get visitation, that is the best interest standard, rather than the current standard, which is actual harm. So in the limited circumstance where a grandparent seeks visitation with a minor child and that minor child's parent has deceased, it basically lessens the burden for the grandparent.
Let me ask you, what if there's not a deceased parent, but a parent whose parental rights have been taken away by law?
So this is a difficult area, because if you are talking about parents whose parental rights have been terminated, you start getting into the area of minor children who have been adopted. And we would have to take a very, very careful look and make sure that children who have been adopted are not subject to third-party visitation petitions from people with the child's prior family. That's not what this bill does. This bill does not reach those situations.
Okay. Who wants to speak next?
Mr. Chairman, do I have a question?
Yeah, Senator Morsi.
To the gentleman that just testified, I want to be clear about the situation where grandparent is petitioning for visitation with child. One or both parents are still alive. They are not incapacitated or incarcerated, and they are not alleging harm to the child. Under B2, in that situation, if grandparent has established a historical, deep bond relationship with grandchild or grandchildren, notwithstanding that there's no harm being committed to grandchild, I understand that now the court could consider that in granting visitation. Is that correct?
No, Senator, this bill does not do that. In the situation that you described, if both parents object to visitation by the grandparent the grandparent must still meet the actual harm burden. If, though, one of the parents is okay with visitation, the grandparent only needs to meet the best interest test.
Okay.
This particular bill covers that odd situation where one of the natural parents has passed away, and the bill would allow the grandparent to prove that the deceased parent would have allowed visitation and therefore is subject to the lesser standard.
Any other questions? Anybody from the committee?
Thank you.
Is anybody who would like to speak who is not spoken from the public? Okay, I think we understand the bill.
Mr. Chair?
Yeah.
Someone just raised their hand.
Okay.
Paula Hill Collins, please go ahead.
Yeah, 30 seconds. Go ahead, 30 seconds, I think.
Okay, I just wanted to say I am one of the cases where my son passed away on Christmas Eve. We had a very good relationship with my son and with my grandson. He was going through a contentious divorce. This bill will allow us to see him. And as Senator Biden actually used the Bible, this shows how important grandparents are. And I just want to tell you all, I want to leave you with a video. And it's a short video, but Ancestry is $1 million industry. Children need their grandparents. Studies have shown that when you lose a parent suddenly and tragically, as my grandson did, he has a 2 to 3-fold increase of having severe mental illness. This is a total different situation. My son would have wanted us to continue to go on. And I have a short video that I just want you to show. This is a child's heart and a child that has already lost his parents. And it will take 30 seconds and I'm done.
All right, go ahead, 30 seconds. Yeah, then I think we're ready to vote. Go ahead.
Are you daddy? I don't, boy don't care.
That was actually taken while my son was in the hospital after he tragically fell. So I just wanted to put a face that these are actually children and they are more important than any legislative law that could be enacted. This is a child's heart.
Okay, thank you. We've got a consensus bill here, I believe. Is there a motion? Moved to report the bill. Is there a second? Second. Moved and seconded to report Senate Bill 1325, the substitute to 1325. All in favor of the motion, vote aye. All opposed, no.
What's that?
All in favor, vote aye. All opposed, vote no.
Senator Servell, you have Senator Boysko's proxy. Ayes 12, noes 2.
Okay, 12 to 2. Congratulations, Senator Donovan. Thanks so much. We appreciate it. Okay, the next on the agenda is Senator Frivola around. Senator Hanger. Okay, Senator Hanger.
Thank you, Mr. Chairman.
And this would be Senate Bill 1435 and also 1437. Senator Hanger, Senate Bill 1435.
All right. Thank you, Mr. Chairman, members of the committee. Senate Bill 1435 looks at, well, actually, I have a substitute. We're dealing with the electronic execution of estate planning documents, and I do have a substitute if you want to.
Okay, is there a motion to adopt the substitute? Been moved, and Senator Obenchain seconds a motion to adopt the substitute. All in favor of the substitute to 1435, say aye. Aye. All opposed, no. Motion carries. Okay, Senator Hanger, what's the substitute do?
Thank you, Mr. Chairman. The substitute basically does everything the original bill was wanting to do, except that it's been being worked on by a number of folks who've made a number of technical amendments. As you all would be aware, for several years, there's been a conversation about electronic signing of estate planning documents, including wills and all of the instruments, advance directives, beneficiary designations, and all of that.
Yes, it is.
And the Virginia Bar Association, for the past couple of years, has looked specifically at that and decided to adopt the Uniform Electronic Wills Act as the starting point, and they've made a number of amendments to tailor that to Virginia law. So that, in general, is what it does. It's a fairly large document. There are people, I hope, online to address Matthew Farley from the Bar Association and others that can get into the detail of the technical amendments they've made and why they think this is something that should be done now. Obviously, as with a number of transactional type things we're doing now, the COVID has kind of brought it to the forefront in terms of the desirability of this type of initiative. So with that, Mr. Chairman, I think that perhaps they're online.
Now, do we have, is it online, the substitute to 1435? And how many speakers? And it occurred to me, maybe this should go to the Civil Law Subcommittee. But go ahead. Who would like to speak first? Huh? No? All right. What? Public comment.
Matthew Farley, please unmute. Go ahead.
1 minute.
Thank you. Thank you. My name is Matthew Farley. I'm here on behalf of the Virginia Bar Association, the Will Trust and Estate section. And I'll address first the issue of what the substitute does. That was those were changes that were made by the VBA and the Clerks Association to clarify some matters relating to probating electronic wills, specifically to provide that the only thing that could be probated was a certified paper copy. The clerks we're not ready for probating electronic documents at this time. And also to make some changes with respect to the probate of foreign wills. So that's what the substitute does. Very quickly, the bill permits the electronic signing of advanced medical directives. It confirms that trust agreements may be signed electronically, and it permits wills to be executed electronically.
Since this is a fairly somewhat complicated, it seems to me we ought to send it to the Civil Law Subcommittee. I apologize, but we got so many other bills we'd like to get out. And that would give you more time to explain it in more detail and to give us a chance to kind of review it. I'm familiar with what you're doing, and I don't want you to go into any extra trouble, but I tend to think that this is something that we need to spend a little more time on. And so without objection, I'm sending it to the Civil Law Subcommittee of Senator Peterson. Is he here? Yeah, okay. Yeah, okay. I think everybody agrees. Without objection, we're sending Senate Bill 1435 of the substitute to it. Did we adopt the substitute? I guess we did. We're going to send that to the Civil Law Subcommittee, and we'll get you informed as to when that's going to meet. Okay? Thank you again. I appreciate the time you've taken.
Thank you.
Thank you so much. Okay.
Okay. Thank you, Mr. Chairman. Then I'll work with your subcommittee on that. The additional bill that I have today is Senate Bill 1437, and it appears that you all have already entertained a bill. Senator Mason had one that was on the same subject, perhaps not quite as broad, that I saw on the floor today. He mentioned that he had something similar to what I had, but what this does, it eliminates the requirement that a promise to appear be completed, a signature for a summons for a misdemeanor offense or administrative violation. It was brought to my attention by a retired police officer, and we vetted this bill with a number of people, and I expect you heard testimony on the other bill, Senator Mason's bill, of a similar.
What's the difference between Senator Mason's bill and your bill, Senator Hanger?
It appears to me, as I glanced at his dealt strictly with misdemeanor traffic violations, I believe, and this one speaks to summons for misdemeanor offenses and administrative violations, but it eliminates the signature requirement. The person after they issue the summons is released, does the same things, just a little bit broader.
Let me ask staff, Charles or Kristen, what's the difference between Senate Bill 1437 of Senator Hanger and Senator Mason's bill?
Mr. Chair, Senator Hanger is exactly right. His bill is a little bit broader in that it also includes not just traffic misdemeanors, but other misdemeanors that can be handled on a summons. It's identical. Senator Mason's bill is identical in part to Senator Hanger's bill, but it's the same thing. It's basically if you can be released on a summons, you don't have to sign the promise to appear before the officer can release you.
Okay, is there any objection to the bill? Anybody support the bill?
Let me ask,
Yeah.
Mr.
Senator
Chair,
Deeds. Senator Deeds.
you know, what if a case goes to General District Court and the court, for some reason, because somebody doesn't show up, continues the case? Is the court not allowed to have the defendant sign a recognizance to be back in court on for the second hearing?
Yeah, Senator Charles, what's the answer?
I guess, Mr. Chair, practically, I'm just trying to think of Senator Deeds' question. Practically, is he asking what happens if the defendant does not sign his notice to appeal, does not show up to his hearing, and the court then
issue so-called
here at a second hearing?
Yeah, City Benjamin, can you answer that? You do.
Sure, the judge would issue a capias.
Yeah,
right.
Exactly. So
the lack of a signature won't prevent a capias from being issued?
No.
Yes.
Okay. Now, is there somebody who wants to speak in favor of the bill? Sean, somebody? Yeah, go ahead. Sean.
Thank you, Mr. Chairman. Sean Winetta, Legislative Liaison with the Humanization Project. We support this bill. We believe it provides another tool for law enforcement to de-escalate. Also reducing incarceration in our local jails, while also preserving public safety. We support the bill as another tool for law enforcement.
Okay, Benjamin Knotts.
On behalf of Americans for Prosperity, we support the bill. Last summer, we were making the case for similar legislation, and we'll say that of all the pieces of legislation on criminal justice reform, this is the one that could have saved George Floyd's life, where the lawmaker can issue a summons and walk away. Same thing for Eric Garner over a cigarette tax. So we do hope you'll pass this legislation.
Yeah.
Thank you.
Any opposition to the bill? Is there a motion? Senator Saslaw moves, and Senator Senator Peake seconds the motion. All in favor of the motion to report Senate Bill 1437, vote aye. All opposed, vote no.
Zero.
14-0, the bill is reported. Thank you very much. Thank you, everybody. Yeah, good. Okay. Senator Marsden, Senate Bill 1458. We're making some progress.
56.
Maybe we won't be here till midnight after all.
Thank you, Mr. Chairman. Senate Bill 1458. This is an administration bill coming to you from the Public Safety Secretariat and the Department of Juvenile Justice. Mr. Chairman, currently, and this bill deals with two issues of the age at which someone can be confined in both a juvenile detention center.
Mr. Chairman, first I think it's 1456.
It's 1456.
Not 58, 56.
1456.
56, excuse me.
1456. Whatever happened in the year 1456, I'm not sure. Go ahead, Senator Martin.
Thank you so much. It deals with the minimum age of confinement in both local juvenile detention and in state correctional facilities for youth. Mr. Chairman, currently there is no minimum age for children to be held in predispositional detention. Those are the 24 juvenile detention homes located in our communities. And this proposal would set an eligibility age of 11 for predispositional confinement in a secure detention facility. Those that are age 10 and under and are charged with a serious offense, offenses enumerated in subsection B and C of 16.1269.1, such as murder, rape, and armed robbery, may initially be detained in a secure facility but may not remain there. In other words, if they just needed a place to put you on a weekend because you're very young and you've committed something serious, is that they can hold you in detention, but once on Monday you go before a juvenile court judge for a detention hearing. From that point on, you would need to be held elsewhere for confinement. And under current law, a juvenile must be at least 11 years of age to be eligible for commitment to the Department of Juvenile Justice. This proposal would increase the eligibility age for commitment to DJJ from 11 to 14 years of age. However, an 11 to 13-year-old charged with certain serious offenses enumerated in Section B and C of 16.1, 269.1, such as murder, rape, and armed robbery, may still be admitted to DJJ. Mr. Chairman, I had 17 years running a juvenile detention center. I had 2 children under the age of 11, one 9 and one 10. The 9-year-old had to be detained because he was looking for attention and took his father's firearm, AK-47, onto a Metro bus twice. He didn't need to be detained in a juvenile detention home. Another child I had at age 10, it was an inappropriate detention. I had to place him in his room because he was emotionally disturbed and wouldn't stop singing the Flintstone song. The other kids were ready to kill him.
You got a problem with that?
You can't put these young kids in detention, and that's what is the essential here. I have some data, if you'd like to hear it, Mr. Chairman, on how many of these younger people have been detained, both in local detention and committed to the Department of Juvenile Justice. It isn't that many. And let me just say this. When I was working at the Department of Juvenile Justice in 2002, you couldn't get a kid into a detention home anywhere in this state. We were packed to the gills because we were trying to teach people lessons. We thought that's what our job was. Instead, we learned that our job was to solve kids' problems. So we came up while I was there in 2002, we started using risk instruments. It seemed foreign to everybody, but they worked.
Just a minute. Go ahead.
Yeah, Mr. Chairman.
I want you to speak. Finish what you're saying, Senator Morrison. Then you'll speak.
I was just going to ask if there's nobody that opposes this bill, I was going to move it be reported.
Okay, go ahead.
I've got a question.
Just a minute. Let Senator Morrison finish whatever he wanted to say.
Well, that is, I was essentially just finishing up, is that it's counterintuitive. You don't teach kids anything. All you do is create damage when you put them in secure
Is there any
confinement.
opposition to the bill?
Mr. Chair,
Yeah,
I've got
Senator
one question.
Dietz.
What's the magic about age 11?
I'm sorry?
What's the magic to age 11?
Well, I think, there is no magic. You
Is an
take the best guesses you can. Children are obviously different.
It's
but
an arbitrary number then.
It is, to a certain extent, a number selected, but it's based on the history of confinement as to how many of these young people there are.
Is this an administration bill?
Yes, it is.
Okay. Does somebody from the administration want to say something briefly?
Amy Woolard, please go ahead.
He's not from the
a couple.
Hello, this is J.K. Davenport. Mr. Chair, members of the committee, good evening. This is J.K. Davenport, Deputy Secretary of Public Safety and Homeland Security. This is an administration bill and we support it. I thank Senator Marsden for carrying this important piece of legislation. It will ensure that children as young as 10 are not held in detention prior to adjudication and promotes the use of alternatives to detention and community placements, which the Department of Juvenile Justice has worked really hard to build out over the years as part of their transformation. The one way that I can address the question about why age 11, DJJ reviewed the data, and there was a big jump between age 10 and 11-year-olds being detained. And so we were guided by the data. We also have the Director of Department of Juvenile Justice available to comment if you have additional questions.
Okay.
I thank you for your consideration and request this committee to report this bill.
Okay, Amy
Thank you.
Woodard. Amy Woodard, would you like to say something briefly? Amy
Mr.
Woodard.
Chairman, thank you. Amy Woolard, Director of Policy with Legal Aid Justice Center. Completely understand the intent of the bill, and we certainly support, making sure young people aren't in detention. I think we have some concerns of still allowing the 11 to 13-year-olds to be detained pre-trial in carceral settings, and some concerns about even setting up a structure for how the under 11-year-olds will be dealt with. We've sort of conceded then that children in that age group can still be culpable of crimes, which I think from our perspective, we're not ready to say that yet. I think we'd rather first see the Commonwealth continue investment in the transformation that affirmatively moves youth away from carceral settings, rather than first identifying these situations where they still will be detained.
Okay, does anybody else?
Mr. Chairman.
Anybody else want to say something? Senator Morrissey?
Yes.
Briefly?
I will be brief. Senator Marsden, you gave, in your 17 years as director, you never saw a situation where a 10-year-old or under warranted incarceration, and the two that did, they were nonsensical. What about 11, 12, or 13? Have you seen situations in your experience where 11, 12, or 13-year-old the behavior that he or she committed warranted incarceration?
It's difficult to say, Senator Morrissey. My inclination is to say not very often, because when we started using risk instruments, we learned that these young people can be supervised in their home through electronic monitoring, to constant visits by outreach workers and what have you, and it's worked. We have 500 kids roughly in predispositional detention today in Virginia. We have 1,420-some beds. It's working, and it just doesn't make kids work, and the drop in crime data and the number of kids being charged in juvenile court has been coming down dramatically since 1995. This is in keeping with good practice. It's good science. It's good following the brain development science that we know today, and so yes, this is a
anybody feel like they need to say something?
One
or is it
final
ready for a
question that's
motion?
very short, Mr. Chairman. Would you consider it a friendly amendment, Senator Marsden, to increase it to under 13 years, move it from 11 to 13?
For juvenile detention, I don't believe the science necessarily picks that up. There haven't been that many of those kids, and we do have other places now that we can place them. Right. They don't seem to be a public safety risk. Public safety risk is the only reason you should detain somebody. You shouldn't be doing it as a foster home or...
I think the bill's in good shape. Does anybody want to make a motion? Been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, vote no.
Uh, 14-0.
14-0. The motion to report succeeds. The bill is reported, 14-0. Thank you very much, Senator Marsden.
Mr. Chairman?
Yeah, Senator Teslaw.
Told Senator Marsden that these things aren't all bad because Babe Ruth got sent to an industrial school for boys, which was a reform school with a fence around it. You couldn't get out.
So learned how
he turned out pretty well.
He learned how to hit a baseball.
He got sent there at age 7.
Okay.
At age 7.
Senator DeSteph, Senate Bill 1430.
Mr. Chair.
And I'm going to give you, I think you spent, how many minutes you want to explain it better?
I'll try to be quick.
I'll turn this over to Senator Dees. I'll be right back.
And this was one we presented, this one we presented last week, Mr. Chairman. What this does is it eliminates one of the Virginia State Police background checks. So today, if a gun is being purchased from a licensed dealer, it goes through an NFA gun, it goes through ATF, then it goes to a licensed dealer for a background check, then it gets transferred, and then it's sent over through VSP. Today, if it goes on a private sale, then it goes through very similar, but it goes through, purchaser wants to purchase the gun from a private seller, purchaser's first fingerprinted through ATF, then they must go through Virginia background check, which is name-based, then they get approval there, then they transfer it, and when they do the transfer, they go through another Virginia background check, the exact same one that they just did. So what this is a duplication and going through the same check twice. What we wanted to do was eliminate one of those checks. To do the transfer itself, so required. And last week, I believe Senator Surville, Mr. Chair, had asked which databases are covered. It goes through the NCIC, National Criminal Information Center, the Interstate Identification File, NCIS, National Instant Criminal Background Check System, the VA Mental Health, VA Protective Orders, VA Wanted, VA Juvenile Records, and then I believe Senator Peterson had brought up something that had happened in his district, and I believe they tried to go to a Walmart to get the background check done. Walmart won't do private sale background checks. There are over 200 places within the Commonwealth that will do them, in almost every jurisdiction. So with that, Mr. Chairman, hope that answers all the questions. Happy to answer any more on Senate Bill 1430.
Mr. Chairman.
Other questions for Senator Surville?
Thank you, Mr. Chairman. Mr. Chairman, we heard this bill last week, and I appreciate Senator DeSteph going back and confirming what I said last week about the difference in checks. And It strikes me that defaulting to a federal check leaves out a whole bunch of very important Virginia checks, including mental health history, concealed handgun permit stuff, protective orders, Virginia wanted list, et cetera. And, given that we're talking about some pretty powerful weapons here, it seems to me that we're good doing it the way we're doing it. And so, having said that and having heard the bill fully, I move that we PBI the bill.
Well, Mr. Chairman, if I may, Mr. Chairman, today it
See
goes
if there's
through.
a second on the motion, and then you can speak to that. Is there a second on that, to that motion? Okay, we've got a motion and a second. Senator DeSteph.
Mr. Chairman, if I may, today we go through that Virginia background check not once but twice. Still, no matter what happens, even when we pass this bill, it'll still go through the Virginia background check once, required by law when it's done, when they do the actual approval for transfer. So it still has to get registered and go through that background check. Today it's going through twice. If we want to continue having it go through twice, so in literally where it goes through twice, most of the time that's happening within 30 days, that it's going through the exact same background check, the exact same databases twice. Mr. Chairman, I'm just trying to eliminate it going through it once, so it only goes through once.
Mr. Chairman, I have a question for the patron.
Senator Morsi.
Senator
Senator.
Thank you. Senator Deese, we're talking about machine guns here, right?
That's correct.
And so basically, the way you'd see it is somebody could say they want to get this machine gun, fully automatic, yeah?
Most machine guns are.
Yeah, right. So somebody wants to get a machine gun, they do this check, and in 30 days between the first check and when they actually get it, they could be found to be mentally incompetent by somebody, but they could still get the machine gun because they didn't do the second check this time, right?
Mr. Chairman, if I may, the entire process, Senator Serville, the entire process takes about 2.5 years to do this. And when they go back through and renew the stamp every year, they go back through it again. But I can tell you that before it's handed to the individual, before they get the approval to do it, it goes through that last check. So it goes through an earlier check before that with the Virginia State Police. The last check is still, upon transfer, it's registered through the Virginia State Police, at which point they go through all of these checks again. So we can eliminate that first one, or we can continue to do it twice. But that second check, when they get the receipt of that, is always going to happen.
Mr. Chairman.
Senator Serville.
Speaking to the bill, I feel very uncomfortable reducing the number of hoops somebody has to jump through to get a machine gun, especially if it's checking for protective orders or mental, or whether they're mentally competent. And I appreciate you think it's making it more simple, but I know a lot of people in my district would be very concerned that we'd be reducing barriers to obtaining machine guns.
Senator, machine guns require 2 people to shoot them, right?
Mr. Chairman, if I may, it requires ATF today, then it goes through, this is only private party
You
sales.
have to have 2 people to shoot a machine gun.
No, Mr. Chairman. One person can shoot a machine gun.
I was taught in the Marines that you need 2 people to shoot a machine gun. One guy is guiding.
That's a belt feed.
Well, no, it can't feed itself. Yeah, but then you got a problem. Anyway, you need really 2 people to machine guns that I was taught to shoot. Okay, anybody else?
Mr. Chairman?
Yeah, go ahead. 50 caliber machine gun.
50 caliber,
Yeah, that's what I use. Okay, Senator Morsi, you got a question?
Thank you. Quickly, Senator DeSteph, I understand your argument about a second level, and if the person has been previously approved, I get that part, and I was there. Senator Serville said, what about the situation where the person has been previously approved and between the time that the person was previously approved and the sale of that machine gun, he is declared mentally incompetent? I think that was the scenario that Senator Serville was trying to address. Could you answer that question for me?
Mr. Chairman, Senator Morsi. So today, if we go through a dealer, you go to buy it, you do a fingerprint-based background check through the ATF. The ATF approves it. Then once they approve it, it goes through a VSP check, and at that point in time, they do the background check and register that machine gun to you. Okay? I want to keep the same process for private sale. Today, in private sale, purchaser requests a machine gun from the private seller. They go through the fingerprint, the ATF background stamp, then they get the approval. They go through a background check there with VSP. They get the approval from VSP. They get the transfer of the weapon. Then they go through another VSP background check. I'm trying to eliminate the first VSP background check, not the second.
Okay, we got a motion before us to pass it by indefinitely. Anybody else want to speak on that? All right, all in favor of the motion to pass the bill by indefinitely, vote aye. All opposed, no.
Ayes 7, no 7.
Ayes 7, no 7. Okay, is there another motion? Been moved and seconded to report the bill. All in favor? It's been moved. It's now the motion. Pay attention. The motion to report. Okay, it's to report. If you like the bill, vote aye. If you don't like the bill, vote no. Yeah, pay attention.
Ayes 6, noes 8.
6 to 8, the bill is not reported by 2 votes. Okay.
Chair, members of the committee, thank you very much for your time.
Thank you very much. Okay, then
Scott.
Senator Lewis has a bill, Senate Bill 1461. Senator Lewis, welcome. Pay attention.
Okay. Mr. Chairman, members of the committee, I have Senate Bill 1461. This is a bill which comes to me from the Sheriff of Norfolk, and you'll be hearing from him in regard to this in just a little bit with the public comment. Senate Bill 1461 seeks to create a new statute of the Virginia Code 18.2-274.2 dealing with it's a statute for bribery in correction facilities. And this results from what the Sheriff of Norfolk and in conversations he has had with other sheriffs across the Commonwealth results from a reluctance or refusal in some situations for Commonwealth's attorneys to use the existing bribery statute to punish those who receive remuneration for delivering contraband into jails or deliver the contraband into jails. And so what this does would allow for anybody who receives money from family in return for bringing contraband into the correctional facility would be guilty of bribery and would be treated as a class 4 felony.
Any questions of the patron?
I've got a question, Mr.
Senate Bill 1461.
I've got a question.
Go ahead, Senator Deeds.
I'm trying to get the exact language, but 18.2-447 already says that a public servant who commits bribery is guilty of a class 4 felony. So what are we doing that's different?
The Commonwealth's attorneys are interpreting the existing bribery, or at least the Commonwealth Attorney in Norfolk and some of the other jurisdictions across the Commonwealth, are interpreting the wording of the existing bribery statute to not include corrections officers because they are not using their discretion. They are not taking money for use of their discretion. I think is the essence of what they're saying. It is how it doesn't fit under the existing bribery statute.
Okay.
I'd like to hear from staff on that point because it seems to me that it is covered under 18.2-447.
Yeah. Yes, Charles. Charles, would you like to explain that? Or Steve Benjamin? I see Steve's shaking his head. Steve?
I don't think it's covered.
He said it's not covered. Okay. It's not covered. So this is a new law, right?
Yes, sir, Mr. Chairman.
Okay. Any
Mr.
questions? Yeah, Senator Serval.
I have a question for council, or the patron can try if he wants, but in light of the Senator Locke's Senate Bill 5030 and the special session, is subsection B really necessary?
That's a good point, Senator Servo. I see where you're going with that. Yeah.
All right. Is subsection B any necessary? Lines 16 to 19.
Mr. Chair,
Yes,
Turn up
Charles.
could Charles and somebody turn up the volume. I'm having a hard time hearing Steve. and
Charles, go ahead.
to the extent that correctional officers need to be included, because correctional officers aren't within the purview of the DCJS decertification process, because they're employed by the Commonwealth. They're not law enforcement officers, and they're not deputy sheriffs. That's the reason why subsection B exists, mainly for correctional officers. It's probably redundant for the law enforcement officers and jail officers, but just to be abundantly clear that if you're a correctional officer and you get convicted under the statute and you want to become a jail officer, I think that's kind of why subsection B is written the way it is.
Ineligible for reemployment as law enforcement officer, jail officer, or correctional officer in the Commonwealth. Okay? All right. Is there any questions of the patron? Anybody want to speak in favor or against the bill? Okay, is there a motion?
Well, Mr. Chairman, I think there is. I do have this. The sheriff of Norfolk is on the line.
Okay, Sheriff of Norfolk. The Sheriff of Norfolk?
Anybody opposed to the bill?
Not that I've heard of, Senator Overchain.
I'd move to report.
Been moved and seconded that Senate Bill 1461 be reported. All in favor of the motion, vote aye. Yes, John?
Finance has requested this bill.
Okay, the finance people want to look at your bill. Okay, it's been moved and seconded that Senate Bill 1461 be reported and re-referred to finance. All in favor of the motion, vote aye.
Thank you, Mr. Chairman.
Thank you.
Ayes 13-0.
13-0, the motion is reported and re-referred to finance. Okay, now we go up to Senator Favola, still not around. Senator Ruff, is he around? Yeah.
I have one.
Well, let's see, Senator Eben, 1381. Okay, trying to get
I have
non-committee
one that you
members.
can do pretty quickly, maybe. It's simple.
Okay, which one is that?
Not uncontroversial, but
14
simple.
1466.
1466. During special session, we adopted the local option to ban firearms in public places and on certain public streets. Talked to Senator Surville. He pointed out that that legislation does have a local option that allows localities to exempt concealed carry permit holders from the application of those bans. What this bill does is it makes statewide that allowance for concealed carry permit holders. This says that if you have a concealed carry permit, you can carry anywhere in Virginia that's not otherwise prohibited, notwithstanding these local ordinances that ban firearms in these public places. This is a policy issue. I would submit that we are creating a patchwork of laws, and this makes uniform the application of that law that we passed during the special session.
Mr.
With
Chairman.
that, I would move its passage.
Mr. Chairman, Surville. Thank you, Mr. Chairman. So Senator Obenchain just referred to Senate Bill 35, which we passed this year. That bill gives each locality the authority to regulate firearms in certain places. Part of that authority is whether or not they would like to extend it also to concealed carry holders. I believe there's one locality in Virginia that exempted concealed carry holders from local ordinances. I think it was Newport News. But I don't think we should preempt our localities on authority we just gave them. And so, having said that, I'd move the PBI of the bill.
Okay, it's been moved to PBI of the bill. Is there a second? Is there
I
any?
guess that would be a substitute motion.
There's some people who like to speak.
Substitute motion.
All right, before we go forward with that, DJ Spiker of the National Rifle Association, you want to say something?
Yes, sir, Mr. Chairman. I'll keep it brief. I thank Senator Obenchain for bringing this legislation forward. As you mentioned, there are a number of patchwork of laws. In response to Senator Surville, it's not limited just to concealed carry. We are seeing a variance in ordinances across Northern Virginia. Some localities are exempting parks where others aren't. What this would do is apply uniformity across the board. So as localities are adopting varying levels, those individuals who are concealed carrying would know that they are uniformity at least on their end. So we certainly support the bill. Thank you, sir.
Okay, if people want to speak, have a different view, Laurie Haas?
Yes, sir, Mr. Chairman and members of the committee. My name is Lori Haas. I'm with the Coalition to Stop Gun Violence. We certainly oppose the bill. As Senator Surville mentioned, we have just given localities the authority to regulate firearms the way they see fit. Local authorities are elected by their constituents. They represent the will of their constituents in their communities, and they should be free to regulate firearms in the way that their constituents and community members want them regulated without interference from the state. And a preemption on a bill that just passed, to give consideration to the convenience of certain citizens and not the overall well-being of the other citizens makes no sense. We urge that this bill be defeated.
Okay, Andrew Goddard, you like to say
Mr.
something?
Chairman.
Yes.
Mr. Chairman, members of the committee, thank you for allowing me to speak on this bill. We oppose it. I'm with the Virginia Center for Public Safety. The carrying of concealed weapons in Virginia is illegal. The only permitted exemption is for carrying of a concealed handgun. Concealed carry of weapons in Virginia is not a constitutionally protected right. It is a permitted privilege. And as such, people should be able to be privileged to be exempt from that one law. The concealed handgun permit isn't a get out of jail free card. It's not an I am above the law card or a permit. And so we don't believe that it should be used to get out of things that people think, laws that people feel are inconvenient. So we oppose this bill.
Okay, thank you. Does anybody else want to speak? Vic Nichols, I believe. Would you like to say something? Vic?
Yes, sir.
Go ahead. Vic Nichols, is that right?
Yes, sir.
Go ahead.
People that have concealed carry do not turn into crazy people when they go into different counties or cities. They pretty much are going to stay the same no matter what. Some people who have the vapors, the instant they see a gun, well, they won't see a gun. They won't know that it happened. People will pass through or whatever. But to expect us to sit there and keep 90 some cities and counties straight who has what is ridiculous. I mean, it's absolutely ridiculous. There's no reason that they can prove, has there anything that has ever happened, ever, where somebody sat there who had a concealed carry and then went to town on one of these places? It just has never happened.
Okay.
All it is we need consistency so we don't sit there and make a mistake.
Okay.
That's all.
Thank you.
Thank
David,
you.
is it David Adams? Is
Mr. Chairman, I've got a question for her.
Yes.
Okay, David
Mr.
Adams.
Chairman, thank you, Mr. Chairman. My name is David Adams with the Virginia Shooting Sports Association. And for all the reasons that Mr. Spiker's already pointed out, our association supports this bill.
Okay. Now, is there a motion?
You already had a motion.
Okay, motion to pass the bill by indefinitely. All in favor of the motion, vote aye. If you want to pass by, vote aye.
Ayes 9, noes 5.
9-5. Okay, thank you very much, Senator Obenshain. The bill has been passed by indefinitely. Okay, the next person is Senator Frivola, not here.
Senator Eben.
Senator Eben. All right, before we do that, Senator Ruff asked that his bill 1371 be passed by indefinitely. Okay. Moved and seconded that Senator Ruff's bill 1371 be passed by indefinitely. All in favor of the motion say aye.
No.
Vote aye. Vote aye. All opposed vote no.
Ayes 13, noes 1.
Except for Senator Stanley. Didn't you get the word, Senator Stanley? Okay. Okay, Senator Eben, Senate Bill 1381.
Thank you, Mr. Chairman. This bill basically codifies and extends, in one case, current state policy of banning firearms in state buildings and Capitol Square. It includes the grounds of Capitol Square, which is the extension, and would limit things like guns and other weapons designed or intended to propel a missile or projectile of any kind, the more serious knives like machetes, razors, slingshots, spring sticks, fighting chains, and throwing stars. And there are exceptions for law enforcement officers and in the course of their duties, others. The notice of these provisions would be posted on the public entrance to Capitol Square and state buildings. And it basically codifies what we currently have.
Yeah, that's what I was going to say. This codifies the governor's executive order. Is that what it does?
For state buildings, but it does add Capitol Square. We have our Capitol Square buildings currently included. I just thought it would be better for the sake of consistency for this not to potentially fluctuate back and forth.
Right, okay. Anybody have any questions of Senator Eben on Senate Bill 1381 that codifies the executive order and includes the Capitol Square?
I do.
Mr.
Yeah, who's that? Senator Morsi? Senator Serval?
Serval.
Serval.
Thank you. Senator Eben, I'm generally supportive of this. I just want to make sure I'm clear, though. This bill would not, right as it's written right now, does not prohibit firearms on Bank Street or, for example, 8th Street, like whatever that street is. It runs next to the bell tower, right?
It refers to the area that is bounded by Bank, Governor Broad, and 9th Street. So no, this is within the square rather than the streets themselves.
Inside the fence.
Got it. All right. I think we ought to do Bank Street too while we're at it, but in any event.
I circulated this to the Capitol Police, and I don't know if they consider Bank Street the area that's pedestrian egress as a sidewalk or not, but I think the way we have it is a good way for a permanent long-term solution.
Okay.
Okay. Is there any further discussion?
Move to pass by indefinitely.
Substitute motion and report.
First of all, there's some people who would like to speak, I believe. Who would like to speak first? Wayne Huggins?
Thank you, Mr. Chairman. As I read the summary of the bill, it says within Capitol Square or into any building owned or leased by the Commonwealth. Retired law enforcement officers who have concealed weapon permits are required to go through annual requalification, myself being one of those people. Does that mean that I cannot carry a firearm onto a state-owned facility for requalification purposes?
Senator Eben.
It does give exceptions for law enforcement officers, conservators of the peace, security personnel, and others, but it doesn't speak to retirees.
Charles, was that correct, Charles?
Mr. Chair, that is correct. That would be an easy amendment if the committee wanted to make such an amendment to add retired law enforcement officers as defined in the code to the.
I move that we amend it to include retired state police to be able to carry concealed weapons.
Motion to add retired Virginia State Police.
Mr. Chairman, Serval.
Is there a second?
Mr. Chairman?
Yeah, first of all, is there a second to the motion?
Well, can I point out that there are other policemen than just state police?
Right.
Before we vote on it?
Offer up your amendment. That's mine.
Okay, we got one amendment that hasn't been seconded. Senator, would you like to make a motion to
vote on mine first?
Mr. Chair.
Go ahead, Stuart.
Can I make a substitute motion
Go
for an
ahead.
amendment?
Go ahead.
That it be retired law enforcement?
Retired law enforcement. Is there a second to that? Retired law enforcement officers. Is there a second to that motion? Substitute motion.
Mr. Chairman.
Is there a second? I don't hear it. Okay. All right, Senator Serval.
Speaking to the motion. First of all, I'm not clear exactly what the motion is, having not seen it in writing. But we've gone through this before with regard to numerous other retired people wanting to be exempt from concealed carry. And one of the questions I always have is, just because you used to be something doesn't mean you left under good circumstances, and it also doesn't mean that you're still okay. I mean, just because you were a judge or a prosecutor or a police officer at one point prior in life doesn't mean you're fine today. And so, I mean, we've read in the papers now that I think there was over 40 retired, or some active and some retired military that went into the United States Capitol. And so just because you had that status at one point in your life, I'm not sure that entitles you to carry a gun all over the place. I think that's why we have our concealed carry system as being the threshold where you have to go through a reevaluation every 5 years. And to me, that's a much more prudent and appropriate threshold.
Charles, what is it now? What's the language now, and what would be the appropriate motion? Charles? It says prevail exceptions for law enforcement officers, servitors of the peace, magistrates, court officers, judges, etc.
Mr. Chairman, I believe it's in buildings they have to train in right now, is what the language of the current statute says.
Okay. Okay.
Mr. Chair, I believe
Charles, go ahead.
Right. So it depends if you are looking to add retired law enforcement officers to the entire statute or to just specific buildings. If it's the entire statute, I would recommend then on line 28 after law enforcement, after section 9.101, insert any retired law enforcement officer as defined in 18.2 I believe it's 308.016. I believe that is the way we refer to the retired law enforcement officers who can
Which line again?
qualify and can carry concealed.
Which line again?
Online, it's 28. Conservative apiece. It would be right after the section 9.1101, retired law enforcement officer, and I believe the cross definition is as defined in 18.2-308.016.
So we shall not apply to any law enforcement officer as defined in 9.1-101 or any retired law enforcement officer. Is that what it says? Is that the motion?
That would be the amendment I would make.
Okay. All right, let's go. It's been moved, and Senator Tesla moved and seconded. Who seconded the motion? Anybody second it? Okay, Senator Stewart seconded. All right. Now, anybody else would like to speak? Wayne Huggins has spoken. Laurie Haas, what's your take on it?
Good evening, Mr. Chairman and members of the committee. We applaud Senator Eben for bringing this bill. It's time to codify the executive order that then Governor McAuliffe put in 2015. It's also incumbent upon this body to keep themselves safe. We think prohibiting firearms on the Capitol grounds, and frankly, it should be on Bank Street so that y'all can safely pass from the Pocahontas building over to the Capitol building when, in fact, that space is opened up. I make note that the Department of Homeland Security issued a warning for the first time in over a year about just this afternoon about threats, coming from certain groups who are unhappy right now with the direction that the country is headed under the new president, and perhaps there are people in the Commonwealth that you would want to consider. Regarding the problem with retired law enforcement, I believe that you could carve out an exemption that would allow them to train in state buildings, but not necessarily carry in every single state agency or state executive office building. So we support the bill. We appreciate the efforts to get it correct and get it straight for all the citizens in the Commonwealth, and we urge you to pass the bill.
Andrew Goddard, do you agree?
Yes, Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill, especially the clause about the Capitol grounds. As for the last 2 years, my organization has tried to continue its permitted annual vigil, and we've been prevented from doing so. And our First Amendment rights have been completely crushed by the fact that the area has not been allowed to be used because of the threat or potential threat of armed individuals being available at that time. And so I believe it's very important that the Capitol grounds be a safe place for people who to come peaceably to do their petitioning of the government.
Okay,
so we support this bill.
Josh Horowitz, do you agree?
Chairman. Yeah,
Mr. Chairman, before we go any further, there's a motion that
well,
these folks are addressing the bill,
I know.
but there's a current motion on the.
I understand. I want to hear what they have to say about the bill and the
Why don't
motion.
we vote on the motion first?
Well, I want to hear what they have to say first. Maybe they have something to say. Josh Horowitz, go ahead.
Yeah, thank you, Mr. Chairman, members of the committee. I want to make a couple points. On the motion, I think we should definitely narrow it. If it's a training issue, say training in state buildings, but we don't want, I think if someone's been retired for 30 years or had 2 years of training 10 years ago, that shouldn't exclude them for all those buildings. I'd make 2 quick points. One, there's no Second Amendment right to carry your gun outside of your home. The Heller decision clearly said hearth and home. That's where the right is. So I don't think we're dealing with the Second Amendment right.
What they have to say. All right. Okay. You finished? Go ahead.
Yeah, and Mr. Goddard said we have a First Amendment right to petition our government. I think that's very important. I, for one, have been, for many years doing this while people have been carrying guns. A couple of years ago, somebody actually hit my elbow with a gun and a funny bone. It was just too close. There's someone who couldn't retain their gun properly. We should not have to deal with that when we're doing our work on the Capitol grounds.
Right now, we have a motion. I want to do this motion now, since we've heard from people. The motion is to add the language on line 28 before conservator to retired law enforcement officers. Is that the language?
I only wanted state police, but
Okay. George, substitute motion. Okay. A voice vote for George substitute motion.
Mr. Chairman,
Retired,
my substitute motion was as Charles described.
Retired law enforcement officers, right?
Mr. Chairman.
Is that right? Okay.
Yes,
All
That's
in
correct, Mr.
favor
Chairman.
the Stewart substitute motion, all law enforcement, retired law enforcement officers, all in favor say aye. All opposed? No. The noes carry the day. Now we back to Senator Saslaw's motion, all retired Virginia State Police. Is that it?
that's it.
Okay, that's it. All in favor of that motion say aye. Aye. All opposed, no. Got some no's? Let's go on the board. All right, all in favor of the motion to allow retired Virginia State Police and on line 28, vote aye if you like it. If you don't, vote no.
Ayes 9, noes 5.
Okay, ayes 9, noes 5. The motion carries. It's now with the language retired Virginia State Police. Okay. Now is
Mr. Chairman.
Yeah, Senator Serval.
Thanks. I got a question for council. Mr. Quagliato, with that amendment, am I correct now that a retired state police officer can carry an AR-15 all over Capitol Square anytime he likes?
Mr. Chair, I believe that would be correct.
Thank you.
Okay. Now, let's see, DJ Spiker for National Rifle Association, what's your position on the bill as amended?
Thank you, Mr. Chairman. DJ Spiker, National Rifle Association.
Well said machine
Our
gun.
objection is limited to the inclusion of Capitol grounds. While the Capitol building and the General Assembly building are both secured with metal detectors, organizationally, the NRA does not support creating more gun-free zones with just signs rather than being a secured area. So our opposition is limited to just the one section, including Capitol grounds. Thank you, sir.
Okay. All right. There's a motion on the bill as amended. Senator Deeds, move to report the bill as amended. Is there a second?
Mr. Chair, it'll be a substitute. And
Okay, this is a substitute. You're calling it a substitute now. Okay. Is the motion to report Senate Bill 1381 as a substitute? It's been moved, and is there a second? Second. Moved and seconded. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, noes 4.
9-4, the bill, the substitute is reported to Senate Bill 1381. Okay, thank you, Senator Evans. Huh? Yeah.
Is she the last person?
If she's around, Senator
She's
Revolt.
downstairs. I can send her
Is Senator Vivola around?
Mr. Chairman?
Yes, yes.
With regard to Senate Bill 1244, my bill, we've got some witnesses that need to move along. Is it possible I could present it now?
Sure.
Oh, thank you.
What bill is it?
Senate Bill 1244.
1244, Senate Bill 1244. And if Senator Vivola shows up, let me know. Okay. 1244, Senate Bill 1244. We're making progress. Civil commitment of sexually violent predators.
All right. Thank you, Mr. Chairman. This bill seeks to abolish civil commitment. I will say this at the very beginning. There is no code section that I find more offensive and more inconsistent with due process and fairness than this civil commitment. This bill would repeal Virginia Code Section 37.2900 through 37.2921, which provides and allows for the Commonwealth to civilly commit somebody under the Sexually Violent Predator Act. Now, let me tell you exactly what I'm talking about. I'm talking about that individual who has been convicted of a sexually violent act, tried by a jury, sentenced, go through the sentencing proceeding, and is sentenced to 30 years in jail. That person finishes his 30 years in jail, has had no incidents in jail, and then he has a civil commitment hearing. And I'm going to discuss that process in just a moment, and then is essentially reincarcerated at the Virginia Center for Behavioral Rehabilitation. Let me kind of set out a little background so folks know. It was 22 years ago that the Virginia General Assembly created a process for committing inpatient treatment those individuals who had committed a sexually violent act. And the process is administered by the Department of Behavioral Health and Developmental Services, DBHDS, and it's driven by a psychological evaluation. In front of you, what was just passed out was a static 99R tally sheet. I want you to look at that for a moment, and I want you to consider this situation. Somebody has been convicted, and a judge had a sentencing hearing, and at that sentencing hearing, that judge considered everything, including past convictions, and sentenced that person to a significant penitentiary sentence, Mr. Chairman. And then, within 6 months of him being released, this person then is reevaluated. And the first evaluation is this tally sheet. Now, if you look at it, items 3 through 10, or excuse me, 3 through 10 has already been considered by the judge. Past crimes, violent or nonviolent. There's a new one, number 2, ever lived with a lover. I don't know what that has to do with anything. And then the age upon them being released. So this is what it does. It has this form, and then if you have a 1, 2, or 3 rating, you're considered an average risk to reoffend. 1, 2, or 3. It's easy to get to 4 or 5, which is above average risk. And if that occurs, then the process is, after being screened by DOC, then there's a committee formed. And that committee includes DOC, DBHDS, a psychologist or psychiatrist, state paid, and a representative from the Office of the Attorney General. You know what it doesn't include? Any representative for the defendant. So a person goes through 30 years, is ready to go home, has committed no other offenses, and is recommitted because why? There's a circuit court hearing, and there is probable cause to find that the person is a sexually violent predator. There's been no other criminal acts or even offensive act or even untoward behavior committed in jail. It reminds me quite frankly, of a Tom Cruise movie where you could look into the future and determine that this person may create a crime in the future. So lock them up in another jail. It's just a different facility. I mean, it is one of the most repugnant things I've ever seen. It is akin to the following. If somebody is convicted of a drug offense, and let's say they have had 4 or 5 previous drug offenses, they're a drug addict, and they're getting ready to be released after 10 years, and you have this hearing where they'll probably use drugs again, you continue their incarceration. My favorite example, and some of the older folk in here might remember, do you remember Willie Sutton? He was a bank robber. Bank robber in the 30s and 40s.
They said, Willie, how come you rob banks? He said, that's where the money is.
Exactly. I remember my daddy telling me that. They asked him, why do you keep robbing banks? Because that's where they keep the money. But he would rob a bank, and he'd break out of jail, broke out 7 or 8 times. He'd go rob a bank. And they told him, what happens if you get out again? I'm going to rob another bank. But he didn't rob the bank yet. And this would be like after he finished serving his sentence, just incarcerate him again because he might commit another crime, whether it's drugs, bank robbery, or any other offense.
Senator, as I understand, I remember this went to the Supreme Court on the grounds of lack of due process. Supreme Court said, well, even though the person has served their criminal sentence, you can commit them for rehabilitation purposes only.
Yes, yes.
And so you're saying it's twisted, so it doesn't really work that way.
Yes.
Right? Yeah.
The Supreme Court has said that, Senator, that you can recommit them. You know what's interesting, though? We don't do it at the beginning of their sentence where they may have some benefit to sending him to this. It's at the very end. And we are predicting that they may recommit, so we'll lock them up again.
Someone has a question. Yes,
Chairman, Senator Stanley.
Stanley.
Mr. Chairman, ask the patron a question, if I may.
Go ahead.
Senator Morrissey, have you been to that facility? Have you been there?
In Nottoway?
Have you been to the sexually violent, the SVP facility?
Have you, Senator Stanley?
Yes, more than once.
Tell us about it.
It's not pretty. And I can't, without divulging attorney-client privilege matters, there's nobody in there that seems like they should be getting out, in my opinion, in my humble legal opinion. They are very dangerous persons that are already there in civil commitment. And so my question is, I mean, at best, wouldn't you want to see if this is the right thing to do? Because these are people who have been deemed to be SVPs, and they are.
The only way I can answer that
and to let them out would be to put children and women and men and our citizens at risk.
Okay, Senator Morrissey, would you like to have
this? Senator, how do you look at that person and they've had a stellar career, or that's a poor choice of word, a stellar period of incarceration, and determine that they will do it again, other than one factor: they've done it before. And I would ask the senator, if somebody had committed 3 murders before, he's locked up for 30 years, and you predict, and it's only probable cause, that he will murder again, just continue the incarceration?
Well, if there's some people here who'd like to speak, let's go.
Well, and if I may, Mr. Chairman, just very quickly,
okay.
And I think he brings up a good point, though. But we're talking about a potential mental disorder, that some of these that are so sexually violent that they cannot, it's a compulsion that they cannot control. And that prison may give them a structure that prevents that compulsion from being acted upon. But once that they're in the free society, that compulsion overtakes them.
Okay.
Now, Senator Morrissey, does the AG support this? Has the AG said this is a good bill, the Attorney General's office?
Oh, no, they're one of the folks that lock them up, keep them going. They're one of the people on the committee, along with DOC and the AG and the psychiatrist paid by the state, that says, we predict they will commit the crime again. Mr. Chairman, I know
there are people who would like to speak one way or the other. So who would like to speak in favor of the bill?
Mr. Chairman, can we put a time limit on it?
Yeah, let's put a time limit. Say 2 minutes per person. I don't know how many people there are. How many are there?
Per side or per person?
Per person. Who would like to speak in favor of the bill? I see 2. 3. Okay. 1 minute each person, and there are 3 or 4 people. Go ahead, speak.
John Hilton, please unmute and go ahead.
Thank you. Good evening. Thank you for having me speak. I just want to say, as a child victim of sexual trafficking who was brought to this country at the age of 7.5 and started being raped and abused and traumatized by a parent at the age of 9.5, and who suffered significant trauma throughout her childhood and young adulthood that led her to be incarcerated, I must respond to the senator. There are no pretty prisons. No matter who you see in prison, it's always going to be ugly, and you're always going to be jaded against that person. But I'm saying here today that I have forgiven everyone that has caused me harm, everyone that has hurt me as a child and as a young adult. And I say to you that a lot of those people had trauma themselves, and we never, ever give them the opportunity to address it, to work on it. And that's why we see this continuation of abuse and violence and hurt, because we don't address it. We should invest in that instead, not into prisons.
You support the bill, is that right? Okay.
Yes, I do support.
Okay, who else supports the bill?
Cynthia Brown, please go ahead.
Hi, my name is Cynthia Brown. I worked at VCBR as an RN for approximately a year. Passed medication to prisoners, assessed sick calls. I noted that during my tenure there, they had very poor floor staffing, low levels of nurses. The care and oversight by senior medical staff was lax, to say the least. The abuse of power over prisoners was rampant. There was a lack of respect for the prisoners' needs. And on top of that, they grouped mentally challenged prisoners in a segregated pod, which I found kind of appalling. There was a constant litany of prisoners with no release dates. For a behavioral facility, it was anything but. There were metal sliding doors, pat downs, room tosses, and they also monitored mail and telephones. And to be honest with you, these prisoners, hundreds of them, I felt threatened one time the entire year I was there by one prisoner.
Mr. Chairman.
You support the bill. Yes, Senator Searle. Go ahead.
I'm sorry, I'm not sure how many more people are left in the queue, but I think I have a sense where this bill's going. There's
Okay.
a lot of people waiting to testify about other bills. We got.
Okay, I understand that. All right, next person. You got 1 minute.
Eric Jensen, please go ahead.
Hello, my name is Dr. Bernita Thompson, and I'm an African-American citizen and homeowner in Hampton, Virginia, with an extensive family in Virginia. I also own and operate 2 schools. The SVP laws have negatively impacted my family personally and a large percentage of other Black families in Virginia. The 2010 census showed just under 20% of Virginians were Black, which still holds true today. Yet over 60% of the men labeled with the scarlet letters SVP are Black. They are forced to serve civil time indefinitely, unconstitutionally restrictions in and out of this shadow prison system that they call VCBR, which is masquerading as a treatment facility after they have already completed their criminal time.
Support the bill. Thank you very much. Yeah, thank you very much.
Please vote for SB 1244. Thank you so much for your time.
Thank you. Johnny Huff, is that right? Johnny Huff?
Johnny Huff, please unmute before, and then go ahead.
Go ahead.
Johnny Huff, you're still muted. Please unmute in Zoom.
Can you hear me now, sir?
Go ahead.
All right. My name is Mr. Huff, a Sergeant Huff, exact Master Sergeant, retired United States Army. I was unfortunate enough to be in VCBR. I had completed my prison sentence, and I was wrongfully convicted to begin with. That was later adjudicated 20 years after spending time in there. I would agree with the young lady who just spoke that this is a shadow prison. There's no therapy there whatsoever. Anybody that would disagree with that, I'd have to argue with.
Okay.
I defended this country, and I love this country. But I am tired of seeing people put away when there's other ways to treat them. Treatment and not prison. I would support this bill.
Okay, thank you very much. Eric, Janice, is that it? One more person. Eric?
Yeah, thank you.
Go ahead.
Yep.
Go ahead.
Yeah, thanks. Thank you. Thanks for having me. I'm a law professor in Minnesota, and I've studied this area for about 20, 25 years, written a book published by Cornell University Press about these so-called sexually violent predator laws. I'll just make a couple of really quick points. Number one, these laws have been held to be constitutional by the U.S. Supreme Court on an assumption that they would be very, very narrowly applied. In practice, they're not. There are few limits on their application. Number two, these laws take a mental health model, expand it, and turn our Constitution on its head. Our revolution was fought to put a limit on the possibility of this sort of government power, exactly this, which is locking people up, not in punishment for a crime, but because we're afraid they might do something in the future. In my opinion, it's a very dangerous concept, and it is contrary to our American Constitution.
Thank you very much. We appreciate. Go ahead.
Mr. Chairman.
All right, well, just a second, Searle. Go ahead, Mr. Janice. You want to wrap it up in another 10 seconds? Mr. Janice, I think I cut you off. All right, okay. Now, I think that's everybody in favor of the bill. Anybody want to?
Mr. Chair, there are a lot more people in favor of the bill.
Oh, okay. State your name. Just a minute, Dick. I'm running this thing. All right. State your name and say in 15 seconds why you support the bill.
Sean, we need to please go ahead.
Sean Winetta, Legislative Liaison with the Humanization Project. We support this bill. If the court believes that they're a danger, then they should be sentenced to a longer sentence. If it's locking somebody up and continuing to lock them up for something that they might do in the future. So we support this bill wholeheartedly. Thank you.
Okay, next.
Chuck Slimp, please go ahead.
Yes, Mr. Chairman, this is Chuck Slimp. I'm the Commonwealth Attorney in Wise County.
Chuck Slimp, Wise County, Commonwealth Attorney. Go ahead.
My bad. It was a misclick. He'll be back in the room in just a second.
Okay, go ahead.
He should be back now. Sorry about that,
Mr.
Chuck.
Chairman, can you hear me now, sir?
Go ahead.
Mr.
Yeah,
Chairman?
we can hear you.
Okay, thank you. Mr. Chairman, I'm Chuck Slimp. I'm the Commonwealth Attorney in Wise County, Virginia. I'm speaking on the bill on behalf of VACA, who opposes the legislation. But I also have a unique perspective on this because before I was elected Commonwealth Attorney, I was in private practice and was a defense counsel in a case appointed to represent someone who was accused of and later committed by a jury to be a sexually violent predator. And so I'll say a couple things from my perspective very briefly, and I respect the committee's time. The first I would say is there is due process, preliminary hearing, civil discovery, appointment of counsel, experts appointed to both sides, a jury trial, and appeals to the Supreme Court. I've been to the facility. I've interviewed clients. They have annual review hearings in front of a court. There's treatment going on. Ultimately, and the thing I want to leave you with, members, is the practical aspect of repealing this thing outright. As of December 31st, my calculation, there are 405 sexually violent predators at VCBR. They're committed there. First of all, they have a predicate of a sexually violent offense, but that's not the standard, not just a sexually violent offense. They have a mental disorder that makes it likely for them to reoffend. And that's, doctors have evaluated that. So we have people who are sick, not just criminals, but people who are sick, and they need treatment. And if this bill passes, those predators who are sick will be released. Half of those individuals would have no probation obligation. And if it's repealed entirely, those who are already on conditional release and there's 274, 75 of those individuals as of December 31st. Those individuals, if it's repealed, will have no probation, no GPS tracking, no longer subject to sexually violent predator treatment. And the last thing I'll say about that, for individuals who need sex offender treatment, the overall concern about raising public safety is this. These individuals, most insurance plans do not cover sex offender treatment. And so financial assistance for people who are going to be thrown out with no home, with no tracking, with nowhere to go, individuals who are sick and who have a propensity to reoffend. On a personal matter, I respect and understand what Senator Morrissey is trying to do. I thank you, sir, for trying to reform this. But as a practical public safety matter, we need to be concerned. It's just not prudent to throw these folks out and get rid of this entire model. So I respectfully ask the measure to be defeated. Thank you.
Are the rest of these people against the bill? All right, go ahead. Who's against the bill? Speak.
Martin Andrews, please unmute and go ahead.
Give you 30 seconds.
Thank you, Mr. Chairman. Thank you, committee, for affording me the opportunity to speak about this. My name is Martin Andrews, and I'm a resident of Prince William County. Some of you might remember me as being the instrumental in the creation of the Civil Commitment of Sexually Violent Predators program that we were discussing today. In 2003, the General Assembly, Governor Warner, Attorney General Kilgore, with the affirmation of the U.S. and the Virginia Supreme Courts, came together with a single unanimous voice to create the Civil Commitment of Sexually Violent Predators program that's now under assault by Senate Bill 1244. Many of you, including you, Mr. Chairman, were personally lobbied by me on behalf of this bill and cast affirmative votes in favor of its creation. At the time, this body recognized the real threat posed by sexually violent predators who are released from custody to once again freely prey on our citizenry and mostly our children. Senator Morrissey has likened this program to punishing sexual predators for crimes they have yet to commit. And I believe that it is a gross mischaracterization of the program from both a legal and purpose perspective. The person he described, the single offender in for 30 years, first of all, that doesn't happen. And number two, that person will not be eligible for commitment under the program. So he is mischaracterizing what it takes to be civilly committed. From a legal perspective, the SVP program is a civil program, not criminal. Prior to their release from prison, the record of every person convicted of sex offenses is examined to determine.
Mr. Chairman, point of order.
He's
He's exceeded his time by three times now.
Yeah, okay. I'm running the show. Okay. All right. And next person who say what your name is and what position you have on the bill. For or against.
Sophia Orlando, please unmute.
Thank you so much, Chair, for having me here today. I am a student at American University. I am 21 years old, and I am a victim of sexual violence and harassment. I appreciate what Mr. Andrews is saying here. I understand where he's coming from. I know he's asking you to think about your children. In many cases, the word "I am" still a child considered by the state. I want to speak to you because I'm also a young woman and passionate about justice and advocating for change. I'm here to challenge you that justice isn't just for you, for me, for Mr. Martin. We don't get to pick and choose who deserves dignity or equality. There aren't exceptions to human rights. We shouldn't lock up people for what they might do in the future or who they could potentially be. That is not how our justice system works. When someone has completed their prison sentence, when they have repaid their debt to society, they deserve to go home. What Virginia is doing to these hundreds of men and their families, indefinitely warehousing them in a carceral setting after the completion of their prison sentences, that is not justice.
So you support
Senate Bill 1244 would end Virginia's failed experiment in this case.
Thank you.
Thank you.
Next, got one more person, right?
Megan Yobos, please go ahead.
Go ahead.
Hello, my name is Megan Ebos. I'm the founder of People for the Enforcement of Rape Laws, an organization founded by and for people who have experienced sexual violence. When I was 16 years old, I was raped by a stranger who had broken into my home. While you might expect someone in my position to support harsher punishment, however, I speak in support of Senate Bill 1244, which would repeal a law that allows the state to commit people convicted of certain sexual crimes to psychiatric facilities after they've completed their sentences. We know that harsher punishment does not make us safer. Fewer than half the states have these laws on the book, yet published research shows that they have no impact on the rates of sexual violence. We know that they do not make us safer, but they do create harm through subjecting individuals to further government control after they've paid their debts to society. Civil commitment for those who have already served their sentences should not be justified in the name of people like myself who have experienced sexual violence. Thank you.
Thank you very much. Now, just say your name and whether you're for it. Give you 15 seconds, each one. Go ahead.
Jerry Fitz, please go ahead.
Good afternoon, Mr. Chair. Jerry Fitz. I'm with the Virginia Department of Corrections, and I'm here for, the Department of Correction has no position, just here for any technical questions that may arise.
Okay. Next person.
Rich Wohlert, please go ahead.
Go ahead. Dr. Wohlert.
Dr. Wohlert, please unmute your mic first.
Go ahead. Unmute your mic.
Can you hear me?
Yes, go ahead.
Yes, I'm a clinical psychologist, PhD. I've treated thousands of sex offenders and been involved in hundreds of sexually violent predator cases. My point is that, and I would encourage the committee to consider the fact that SVP commitment laws were passed 30 years ago, but they lack psychiatric acceptance and scientific validation still at this date. The official position of the American Psychiatric Association is that SVP laws undermine the legitimacy of the medical model of commitment. There is no such thing as a mental abnormality in the Diagnostic and Statistical Manual of the American Psychiatric Association, even though the DSM diagnoses are used as proxies for mental abnormalities. And the DSM Diagnostic Manual does not discuss, has never discussed the concept of a mental abnormality. And this is because the Psychiatric Association believes the concept is largely invalid. From a scientific standpoint, the reliability of the diagnoses are inferior, they're negligible. The definitions of the main terms, mental abnormality, volitional emotional impairment, menace to others, are too vague to be used scientifically. And the recidivism rates for SVPs are very low, and particularly for Virginia. I've got data that indicate that the recidivism rates for those who have been released, convicted as SVPs, but then released to the community is on the order of 2%.
Yeah, thank you very much. I wish we had a lot more time, but we don't. Is there anybody else? Is there anybody else that has? How many people are out there on this bill that want to speak? Do we know?
Looks like at least 4 more.
4 more. All right, can you just state your name and whether you're for or against it very quickly?
Garnett, please go ahead.
My name is Garnet Robbins Spoffman. I'm Just Future Project, and the 2 lawyers that spoke, Martin and the other one, are completely, utterly wrong.
Okay.
There's a 15-year-old who was
Point of
15.
order.
He
She's
had
not
one
stating her
charge.
position, Mr. Chairman.
State
He
your
is
position.
one-
Give your name and
excuse
state your position. What are you for or against
My
it?
position is you all are misrepresenting information and completely inaccurate information.
position
and
you're-
you're stating it as fast.
What
I
is
am
your
absolutely-
position? You
I am for SB
Okay.
1244.
Okay, thank
and I
you.
want you all to
Okay, next.
Lynetta Thompson.
You state your name and whether you're for it or not, against it, that's all. State your name and whether you're for it or against it. State your name, please, and are you for or against the bill?
Lynetta
Thompson. Yeah, I am for the bill,
Okay.
but I will have to differ with one of the senators that said that people cannot fall through the system. I am the past president of the Richmond NAACP, and I advocated for a gentleman that did 35 years in prison, made parole, did excellent stuff in the prison that the prison is still using today. Upon his parole, 6 months, as was said, he got a letter for civil commitment. His crime was committed when he was 15 years old. He never made it to the street. So he was civil committed, and then he was
Okay, thank you very much. Thank you.
VCBR. But this bill is very unjust, and there's no due process for the individuals that have done their time.
You support the bill. Thank you very much. Now, nobody else is to speak. Senator Morsi, you've opened up a can of worms. We need about 6 years to study this. We can't do it today. I suggest we go to some study or something.
Mr.
Okay?
Chairman.
Yeah, Senator Morsi.
Servo. Thank you, Mr. Chairman. The Senate Finance Committee put in a budget amendment last year which produced a study which recommended that we start treating these people at the beginning of their incarceration in prison. They've recommended that we do another $1 million to do that in the coming year. I think we need to sort of continue that process, see how it goes. In the meantime, I think this bill ought to go to the Crime Commission where they can look at it in conjunction with the information coming back from that study that's going on. So I move to PBI the bill with a letter from you, Mr. Chairman, asking the Crime Commission to look at this.
Is there a second? Any discussion? The motion is to PBI the bill with a letter from the chairman to the Crime Commission to study the bill. All in favor of the motion say aye or vote aye. I wish we had 10 hours to study this.
I know.
Yeah, I know. Yeah. All right, thank you. Now, do we have another bill that's not this long?
Thank you for the time, allowing people pro and con to speak.
Okay.
And I've got 3, and I have witnesses.
Senator Favola, I promised her. Senate Bill 1382.
No, I had another one, but I'll sit down.
Well, let's see. You sit down. You've been there too long. All right, Senator Favola, Senate Bill 1382. Favola. And you got a bill going to finance. You got to go to finance. 1382.
Mr. Chairman, just a point of information. You did roll my 1383 into 1315. Haven't gotten there yet? Okay. Okay. Mr. Chairman, I'll speak now to 1382. What this bill does is it creates a new section in the code which essentially would prohibit the purchase, possession, or transport of a firearm following an assault and battery of a family or household member if an individual was convicted of a misdemeanor in this category. What my bill does is it follows the current federal law and puts it into state statute. So the definition of a household member is the federal definition, which is more narrow than the state definition. As you can see, it does not include siblings. It's a very narrow definition. And when we get to the question of assault, we are using the federal definition, not the state definition, because the federal definition actually talks about the use of physical force or threatened use of a deadly weapon. The state definition gets into the possibility of sexual assault, which is very difficult to define.
Mr. Chair.
Yes, Senator Deeds.
My question is, if you're following federal definitions,
Yes,
not
sir.
the state definitions, and this is already covered by federal law, why
is.
do we need a state statute?
Mr. Chairman, and Senator Deeds, I believe, as do others, that there is value in putting it in state statute because there's a higher probability we will be able to actually prosecute. Frequently, our law enforcement folks turn to the state statutes, so they don't go looking for a federal official to go ahead and be the prosecutor.
Okay.
So I'm looking for more prosecutions.
Anybody would like to, any more questions of the patron?
I got a question.
And I do want to say that if an individual knowingly violates this provision, it's a Class 3 misdemeanor, no jail time, up to $500 fee. So I thought, pretty generous.
Senator Peterson has a question.
That was my question. Is there a minimum mandatory for this?
It's a Class 3 misdemeanor, so there's no jail time.
Okay. Anybody would like to speak in favor of the bill, raise your hand and go ahead, pick.
Haas, please unmute and go ahead.
Lori Haas.
Good evening, Mr. Chairman and members of the committee. My name is Lori Haas. I'm with the Coalition to Stop Gun Violence. We absolutely support this bill. There's value in having this prohibition in the code in the Commonwealth of Virginia, as the patron suggested. We've learned of situations where a person prohibited under federal law, is stopped by a law enforcement officer, and that law enforcement officer has no authority to enforce that federal law. We want these persons who have been convicted of these certain very narrow misdemeanor crimes to actually enforce the prohibition on these firearms. A history of violence is the single biggest predictor of future violence, and to leave these people armed makes no sense in the Commonwealth. And again, this prohibition already exists. We need our citizens to follow this prohibition, and one of the best ways to do that is to give our public safety officials the tools they need to enforce the law.
Thank you. 1 minute. Andrew Goddard. Go ahead, Andrew. Andrew Goddard.
Andrew Goddard, please unmute and go ahead.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. For all the reasons my colleague, Ms. Haas, has just stated, we support this bill.
Okay.
Thank you.
Josh Horowitz.
Yeah, thank you, Mr. Chairman. Josh Horowitz, Educational Fund Stop Gun Violence. We support this bill. We support it because we want Virginia law enforcement to be able to enforce the gun crimes here and make sure that people who are convicted of domestic violence don't have access to firearms. If we leave it as a federal offense, we risk the fact that only federal law enforcement will work on this. And one of the problems with that is that often we see federal law enforcement not prioritizing domestic violence, and we know that this is a real risk for women and other folks. So we support the bill and believe that Virginia Commonwealth attorneys and law enforcement should have the power to enforce this offense.
Next one.
Chris Sigler.
Mr. Chairman, members of the committee, good evening. Chris Sigler, Fairfax County, and for the reasons already stated, Fairfax County also supports this bill.
Okay.
Thank you.
DJ Spiker.
Thank you, Mr. Chairman. DJ Spiker. While we support the goal of this legislation, and again, as I mentioned before, it is federal law, we feel this, unfortunately, due to some of the existing issues in Virginia code, this goes well beyond federal law and creates a number of new classes that disagree and contradict federal law. Specifically, the definition of family at the state level is far more broad than the definition at the federal level. The patron mentioned that siblings is not, while not included in a line item in subsection B, so line item V in subsection B, any individual who cohabitated with the person within the previous 12 months can be applied to siblings. The use of force, as this body is explored over the special session, as far as assault and the definition of assault, is well beyond the definition at the federal level. And both of these, the cohabitation, the classes, and the definition of assault go well beyond what's in the federal statute. If we were able to mirror federal, we'd be okay. Existing federal law on assault and on definition of families is well beyond the federal definition. Thank you.
Thank you. Next.
Philip Van Cleve.
Philip Van Cleve. Okay.
Philip Van Cleve, please unmute and go ahead.
Yes, this is Philip Van Cleve with the Virginia Citizens Defense League. Our position on this bill is we strongly oppose. This thing creates a lifetime ban on firearms for a misdemeanor. There's no way out of it. It's a lifetime ban that you lose a civil right. And consequently, we strongly oppose this. Now, if it did the following things, we would be fine with it. Number one, if it followed federal law for definition of domestic violence. Number two, if it took away all civil rights. And number three, if it had a provision to give back those rights, assuming something reasonable is done, you go to court, you appeal, and you can get back all of your rights. That would be something that we would not oppose.
Okay. All right. Brady Kelsey Rogers.
Great. Thank you. Good evening, Mr. Chairman. My name is Kelsey Rogers. I'm Brady's Senior Manager of State Policy. We're in strong support of SB 1382. We agree with all the statements made by Ms. Hawes, Mr. Goddard, Mr. Horowitz. I won't repeat them. I know you're trying to move quickly. I will just say we do know the dangerous link between access to firearms and crimes of domestic violence. The proposed bill will protect those at risk and keep guns out of the hands of those likely to harm others. We appreciate the work of the committee and the patron. Thank you.
Any more questions from the committee? Is there a motion? Move it to report. Is there a second? Senator Sasslaw seconds the motion. And re-refer to finance. Be reported and re-referred to finance. Any discussion? All in favor of the motion to report and re-refer to finance, vote aye. Sasslaw? Peterson?
Surprised it was a re-referral to finance, but.
Okay.
Noes 5.
8 to 5, the bill is reported and re-referred to finance. All right, Senator Favolo, you have another one, 1383?
Yes, Mr. Chairman, 1383 is identical to Senator McClellan's bill 1315. I would respectfully ask that my bill be rolled into 1315. And,
So moved.
And that I be chief co-patron on Senate Bill
Okay.
1315.
The motion to roll Senate Bill 1382 into Senate Bill 1315.
1383
I'm sorry.
into Senate Bill 1315.
Yeah, 13083. Okay. I'm
Yes,
sorry.
sir.
1383 and 1315. Okay. Is there moved and seconded that 1383 be rolled into 1315? All in favor, it's been moved and seconded to do this. All in favor of the motion, vote aye.
Ayes 12, no 0.
12 to 0. The motion carries. The bill is rolled, 1383 is rolled into 1315. And both, and be co-patrons, both of them.
Mr. Chairman.
Yeah, okay, next,
Sure will.
Turble, go ahead.
I have a bill we did last year that I have witnesses for that we passed last year. Can we do that real quick?
Hey, Servo, if you can wait just 2 seconds. I got 1107, and the chairman and I agreed that we would pass it by and send it to Monday since this will take a lot of time. But I think there's some people that may be watching this hearing that would like to get off and have dinner with their family. So, Mr. Chairman, with your permission and your agreement as previously given, I'd ask that Senate Bill 1107 be carried to Monday's hearing.
Senate Bill 1107.
Yes, sir.
Carried over. Did you have somebody speak now or not?
No, sir.
Okay.
I've told them all that this is going to go long.
Bill 1107, dealing with the medical malpractice cap, be continued till Monday at 8 o'clock.
Thank you, sir.
Mr. Chair.
Without objection. Yes, Senator Deeds.
If your intent is to go a long time, I want to get my bills done, but if not, if I've got witnesses, I think, on both those bills, and if you want to put 1266 and 1184 to Monday, we can do that, but if you want to...
Well, let's see, which one are we talking to?
It's 1266 and 1184.
All right, let's see, 1266.
I know there are people here on both those bills.
Okay. 12, let's see, this, Senator Deeds, 1266, which you want to hear first? 1266 or 1184?
What?
Did you want to promote? Go ahead, what do you want to do?
Well, I can go either way, but I think there are people on the line on both these bills, and if you're going to put them Monday, let's go ahead and let the people go, and
Well, can you do it, would you like to do it now?
I can do either one now. I can do 1266. I know that there are people here.
Let's do that.
And I got people here too. We all do.
Okay, we got to do one at a time. I can't do two at once.
Okay,
All right.
1266.
1266, Senator
is
Deeds.
simply a bill that does away with the presumptions against bail. The Eighth Amendment of the United States Constitution guarantees that there won't be excessive bail. And Article 1, Section 9 of our Constitution makes the same guarantee under state law. But still, since about 1996, we've been imposing, I've been voting for them, these presumptions that bail won't be granted in certain instances. I don't think they're fair. I think the judge still has a right. You know, when you're granting bond, the main considerations are whether or not the public's going to be protected and whether or not the person's going to show up for court. The judge still has the ability to decide that a person is too dangerous or that he's too much of a flight risk to refuse bond. And all this bill does is say that there's not going to be a presumption against bond in any case.
Okay, we got some people who'd like to speak in favor of the bill. Go
Mr.
ahead.
Chair, I don't mean to stop, but I think Senator Deeds had an amendment.
Okay.
Okay, what's
on line 20? It would insert family or household members as defined in section 16.1, 228. So basically, the bond would provide that his liberty would continue to be an unreasonable danger to himself or to his family members or to the public. That would be one of the considerations.
What line?
Line 20.
Line 20.
After himself,
okay,
a comma, and then family or household members as defined in section 16.1, 228. And the amendment is available online.
That simply adds a specific consideration of danger to family or household members. I'd move that amendment.
Second the amendment.
Okay, all in favor of the amendment say aye.
Aye.
Aye. All opposed, no. Motion carries. Okay, is the bill ready to be heard by the public?
I'll move to report.
Well, it's got people here who'd like to say something. Very briefly. State your name and whether you support it or not, and you can, 30 seconds.
Eugene Oliver, please go ahead.
How many people do we have? Eugene Oliver, go ahead.
Thank you, Mr. Chair. My name is Eugene Oliver. I'm president of the Virginia Association of Criminal Defense Lawyers. We support this bill. Senator Deeds identified many of the positives that this bill would do. It's a basic issue of fairness. This is a bond presumption that's inequitably applied across the state. We'd ask for your support on this bill. Thank you.
Okay, next in favor.
Sean Winetta.
Good evening, Sean Winetta with the Humanization Project. We support this bill, believe it helps preserve public safety, and we ask that you report it.
Okay, next person.
Stacy Davenport.
Good evening, Stacy Davenport on behalf of the Virginia Association of Commonwealth's Attorneys. We oppose this bill. Many of the crimes that currently have presumptions are crimes of violence and crimes that have actual identifiable victims. If this bill passes, the magistrate or judge would only have to consider whether or not a defendant appears and whether they are a danger to themselves, the community, or a family member. Currently, with a presumption, which, as you know, recently, just this past year, the statute was amended to allow both a magistrate and a judge to overcome that presumption. Specifically, they have to consider things in addition to what I just mentioned. For instance, the nature and circumstances of the actual facts of the charge that is before them, as well as the specifics of the criminal history of the individual that is before them. We believe that this puts dangerous people out, and these are things that need to be considered, so we do oppose the bill.
Okay, next.
Lakeisha Cook.
Good evening, Mr. Chairman, members of the committee. My name is Lakeisha Cook from Virginia Interfaith Center for Public Policy, and we strongly support this bill. Thank you.
Thank you. Next.
Dominique Martin.
Good evening, Mr. Chair, members of the committee. Dominique Martin, New Virginia Majority. These pretrial detention causes major disruptions in the people's lives, often unnecessarily so. The pretrial situation is inequitably applied, as stated before, and particularly affects communities of color and low-income communities. And for those reasons, we hope that you support the bill.
Okay, thank you. Next. Next in favor.
Jenny Glass, please go ahead.
Hi, Chairman and committee members. My name is Jenny Glass. I'm the Director of Advocacy for the ACLU of Virginia. We support this bill and we urge that you pass it and remove these unnecessary presumptions against bail. The government should be the one to justify detention, not the accused. Thank you.
Okay, next.
Brad Haywood, please go ahead.
Hi, Brad Haywood with Justice Forward Virginia. We support the bill. The Supreme Court of the United States said that liberty ought to be the norm. Right now, we have a system where detention is the norm, And it's the norm because of legislators in Richmond saying in certain cases that things should happen, that people should be held. Those determinations shouldn't be made by legislators. They should be made by judges. Are judges really incapable of determining that somebody charged with murder should be held in jail before their trial, or somebody charged with an armed carjacking should be held in jail? No, they're perfectly capable of doing that. The law already enables smart decisions on these facts, and we don't need a presumption. Essentially, they operate like mandatory minimums at a pretrial level. So
Okay.
thank you.
Thank you. Next.
Maisie Austin.
My name is Maisie Osteen, and I'm a lawyer with the Legal Aid Justice Center, and we're in support of SB 1266. A fair and just system must be committed to the consideration of individual circumstances in every case, no matter the accusation. LAJC and many of our community partners urge you to report SB 1266.
Okay, thank you. Next.
Jessica Sapalio.
Thank you, Mr. Chair. My name is Jessica Sapalio, and I'm with the Williamsburg James City County Court Watch and the Pretrial Justice Coalition, and we are in strong support of this bill. We regularly see large numbers of people held pre-trial due to these presumptions, yet we know that judges have the ability to decide who should be held and who is a risk. These presumptions against bail purely serve as a mechanism to increase our pretrial populations, costing the state significant amounts of money and disrupting lives. Please vote in support of this bill.
All right, thank you. Next, anybody else?
Galen Knutson.
Yes, Galen Knoyton. I'm the Political Action Chair for the Virginia State Conference NAACP, and we're in strong support of this bill. Thank you.
Thank you. Next.
At this time, there are no other hands, Mr. Chair.
Anybody else against?
Mr. Chair.
Move to report. Yes. Go ahead. Who said move to report?
That was Joe Morrissey.
Joe Morrissey moved to report, and is there a second? Senator Deeds? Second to motion. Is there any further discussion? All in favor of the motion to report the bill, vote aye. All opposed, vote no.
Ayes 9, noes 4.
9-4, the bill is reported. Okay, thank you very much. Senator Deeds, you have 1184.
1184 is simply a bill. 1184 is simply a bill, and I think there's a substitute.
Mr. Chairman, the substitute should be posted, but we're having some difficulties with LIS. I'm not sure if you're going to be able to see it or not. I can explain it if you'd like me to.
Go ahead, Kristen.
If you want.
The substitute adds language to 2 definitions, and then throughout the rest of the section dealing with standby guardianships to make it clear that we are expanding the qualified parents for standby guardianship to people who are anticipating being deported or incarcerated or detained based on an immigration proceeding. So it just makes changes throughout the entire standby guardianship chapter in line with what Senator Deeds' goal was.
Mr. Chair, I'll move the substitute if you're prepared to go forward without actually seeing it. If you want to wait till Monday, that's fine with me.
Looks like all LIS is down.
Well, we have, we'll hold that up. But there are people here who would like to speak, even though we take it up again on Monday. We go ahead and speak, whoever there is.
Edgar Lara, please go ahead and unmute.
My name is Edgar Lara. I'm speaking in support of SB 1184. I'm a board member with Sin Barreras, or Without Barriers, Charlottesville nonprofit, working to empower the immigrant community. In our work, we see and speak to hundreds of people with families that are doing the best they can to be law-abiding members of our community and hoping to live in peace, but many run the risk of being arrested, detained for months or longer, and deported because of their lack of immigration status. We advise them to have a family safety plan for this situation and share it with people they trust. But part of the plan is to create a power of attorney stating their intentions for a guardianship of their children. We know these documents are only good for 180 days, and all we can do is hope that the parents' intentions might be honored by the court, schools, and other institutions, but that answer isn't good enough, which is why we urge you to support SB 1184. Parents should be able to determine how their children are cared for and designate trusted guardians should they be detained, incarcerated, or deported.
Okay, thank you. Next person.
Dan Vogus, go ahead and unmute.
Yes, I'm also associated with Sin Barreras, and I, of course, favor this bill, and I concur with everything that Edgar just said about it, that we want to make sure that parents have control over the future of their children. We see this as a family-friendly bill, and we would urge the committee to support it. Thank you.
Thank you. Next.
Jasmine Fernandez, please go ahead.
Hello, everyone. Good evening. My name is Jasmine Fernandez. I serve as an advisor and the anti-racism program manager for Albemarle County Public Schools. And in alignment with our equity mission and our anti-racism policy, we fully support this proposed bill. The ability to identify a standby guardian for families impacted by detainment or deportation will help to ensure children do not fall behind in school. And while we may not have the specifics of how many Albemarle County Public School students have been impacted, I can tell you that in the past couple of weeks, we have talked to a number of educators, and they too have emphasized how the lack of a stable home during the midst of a family deportation, especially during the pandemic, has impacted their students. And so the reality is we know that the psychological and emotional scars are long lasting, but the ability to have a standby guardian will help to bring a level of stability and support to students. Thank you so much.
Okay, next.
Sandra Garrison, please go ahead.
Mr. Chair, I'm advised LIS is back up. If you want, we can move the substitute.
Okay, let's hear what Sandra has to say, and then we'll do that. Sandra?
Mr. Chairman, thank you. Good evening, members of the committee as well. Sandra Carrison, Office of the Executive Secretary, Supreme Court of Virginia. The court does not have a position on the bill or has a position of no position. What I wanted to express this evening was appreciation to Senator Deed's office for working with us on the bill from the introduced version. And I haven't had an opportunity to see the substitute posted, but the only last concern that we had based on what we had seen was an incongruence with the definition of the standby, the qualified parent, which, but it sounded from Ms. Walsh's description that has been addressed in the substitute that's been posted. So I'll take a look at that and appreciate that further work and also conversations with the proponents, by the way. So thank you for the opportunity.
Mr. Chair, that's exactly what's done in the substitute.
Yeah.
Well, the differences between the bill and the substitute were made to address some issues the Office of the Executive Secretary raised about that precise definition. As I said, even with that change, the Office of the Executive Secretary still takes no position. The court takes no position, but that's what the substitute does.
I move the substitute, and Senator Saslaw seconds.
All in favor of the substitute, say aye.
Aye.
Aye. All opposed, no. Substitute's adopted.
Move to report, Senator Boysko seconds.
Let's take a look and see what the substitute does.
Okay, the standby guardianship was established about 23 years ago, basically for people who were on their deathbed. It was a request from the AIDS community from I think the Hampton Roads area in about 97 or 98, and that's how we established the program. With the threat of deportation, there are other people, and whatever you think about people that need to be deported, they've got kids. Those kids have to be cared for, and parents care about their kids. And so this bill is to extend the standby guardianship to people who are under threat of being deported or going to jail.
Okay. I think we understand it. Is there a motion?
Move to report.
Moved and seconded to report the bill, the bill as amended. Senate Bill 1184. All in favor of the Senate Bill 1184, vote aye. All opposed, vote no.
It's 13-0.
13-0. The bill is reported, and thank you all very much. And now, do we have anybody else out there who wants to speak about anything?
Mr. Chairman, I have witnesses on two bills here.
Okay. We got two. Any of them simple?
I think so. We passed one last year.
Oh, you're not talking about Senator Morse's bills, are you? Okay.
No.
Okay. Simple bill we did last year. What is that, Senator Serval?
Thank you. Senate Bill 1180.
Okay, 1180. Okay, this is the class action suit?
It is, Mr. Chairman. I have a substitute, which I would now move.
It's been moved. Is there a second?
Senator Boysko seconds my motion.
Senator Boysko seconds the motion. All in favor of the substitute for Senate Bill 1180, say aye.
Aye.
All opposed, no. Motion carries. All right, refresh our recollection as to your class action lawsuit.
Thank you, Mr. Chairman. The bill that, the substitute just basically changes the words and makes it a little clearer. The bill hardly has any words in it. So, but basically, Virginia is the only state, us and Mississippi, the only two states in America that don't have class action lawsuits at the state level. And this basically would require the Supreme Court to promulgate rules requiring it. They're no more restrictive than the current rules in federal court. The bill is not effective until July 1 of 2022. It asked the Supreme Court to develop the rules by November the 1st. So the only thing I'll say is Virginia is an outlier. As I said, it's us in Mississippi, that's it. Class actions to promote judicial efficiency. Just to give you an idea, like when the Volvo thing happened in Fairfax County, there were over 400 cases filed over Volkswagen because the people couldn't join the class action. There's the Chinese drywall case. These things could all be consolidated and brought as one case together. This will solve a lot of problems. This will also supplement a lot of the bills that we passed last session to give people the remedy they need. And a lack of a class action remedy leaves a lot of Virginians vulnerable to fraud. The bill is supported by the Poverty Law Center, the Trial Lawyers Association, Public Justice, the National Consumer Law Center. I'm happy to answer any questions, but again, we debated this at length last year, and nothing has changed. I believe there's at least 2 or 3 people online that want to speak in favor of the bill.
Okay, who wants to speak in favor? Go ahead. No more than 1 minute, please.
Leonard Bennett, go ahead.
Thank you, Mr. Chairman. I am on the board with the National Consumer Law Center, on the advisory council now at Virginia Poverty Law Center, and I look at all the different participants you see here to speak, and they're not, they're legal aid, public interest organizations, and that is the biggest beneficiary of a change that Senator Survell proposes, which is to allow a group of individuals to seek relief without making the judge in the trial court, if it so chooses, handle the same case again and again. If a legal aid organization is needing a reform for a group of tenants in an entire apartment complex, all these new employment rights. If there are large damages, those cases really aren't going to be ever appropriate for class certification because they're individualized. But if a judge finds that the superior, the judicially efficient way to handle a group of common cases is in a class, we should join the 48 other states that have been doing this effectively for a while. The only thing I'd note is that the Class Action Fairness Act and other protections would avoid the kinds of classes we don't typically see here in our federal court either, which are these rip-off settlements. The judge can enforce that and the Supreme Court rules could prevent, but it's time that we join the rest of the country.
Okay, thank you, Lynn Bennett. We appreciate your comments. Next.
Brenda Castaneda.
Mr. Chair, Senators, thank you. I'm Brenda Castaneda. I'm the Legal Director of the Economic Justice Program at Legal Aid Justice Center, and we strongly support this bill to allow courts to consolidate actions by a plaintiff on behalf of others with claims rising out of common questions of law or fact. This bill will allow low-income Virginians to vindicate not only their rights, but the rights of other low-income Virginians experiencing similar mistreatment by the same actors. So often when we're able to bring cases only on behalf of our individual clients, unscrupulous defendants view paying out those claims simply as a cost of doing business and do not change their ways. For instance, we've lately had more and more experiences with large out-of-state landlords buying complexes in Virginia and then failing to follow state laws for things such as submetering utilities. And we may only be able to challenge the practice for a small number of folks for a small amount of damages each. These landlords thus have little incentive to learn to abide by Virginia landlord-tenant laws. Likewise, another common issue we encounter is employers failing to pay overtime or skipping final paychecks. And often we only see a few of those employees who are able to find us and ask for representation. So those businesses may consider these just nuisance claims as a cost of doing business, thus continuing to allow them to cut corners and giving themselves an unfair advantage over their competitors who choose to honor labor laws. So we hope that you'll support the bill as well, and thank you for your time.
Great, thank you. Next.
Christy Kelly, please go ahead.
Thank you. My name is Christy Kelly. I'm a consumer lawyer. I'm on the board of the Virginia Poverty Law Center, the Legal Aid Justice Center, the National Consumer Law Center's Partners Council, and the board of the National Association of Consumer Advocates. We all support this bill because it promotes access to justice for individuals who could not otherwise afford a lawyer. The court system should be something where individuals, regardless of the amount of money they have, can get redress for wrongs. A good example would be a predatory lender. Lenders who are online and come into Virginia take away business from legitimate Virginia companies trying to use loopholes, charging Virginia consumers 900% interest for a $300 loan. Without the ability to enforce Virginia's state usury law, we could only get redress for one person. If we had a Virginia class action mechanism, we could get redress and bring millions of dollars back into the Commonwealth and encourage Virginia consumers to do business with Virginia companies rather than allow out-of-state individuals to come into our state and evade our laws and take money from our consumers.
Okay.
There's got to be a
Mr. Chairman,
mechanism.
have these two speakers used up all of the time in
That's
favor
okay.
of this bill?
Next. Who's?
These speakers are going for
Yes, Senator Overton, I understand.
well over the time limit that has been set.
Thank you. Next,
Jay Spear, please go ahead.
Keep it to a minute, would you please?
Mr. Chair, Jay Spear with the Virginia Poverty Law Center, and I would echo what the other speaker said. We support the bill. Thank you.
Okay, Mark Dix.
Good evening, Mr. Chair, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill and echo the previous comments.
Okay, Jeff, thank you.
And also notice about judicial efficiency. Thank you.
Yeah, Jeff Palmore.
I'm opposed.
Opposed? You opposed to it? What's your position, Jeff?
Opposed.
For the Virginia Bar Association or what?
For the Virginia Chamber of Commerce.
Oh, of course. All right. Thank you very much. Anybody else want to speak one way or the other on the bill?
Well, I'd like to speak if that's an opportunity.
Whoa, Mr. Chairman.
Yes, go ahead.
I mean,
okay.
you gave lots of time to everybody
okay,
else.
I'm saying, does anybody else want to speak on the bill? That's what I'm asking. One way or the other. Okay, Jeff, you want to say anything else besides that?
Yes, Mr. Chairman, members of the committee, Jeff Palmore on behalf of the Virginia Chamber of Commerce. We're just seeing the substitute now, but I think would actually agree with one of the comments made earlier by Mr. Bennett, that one of the big challenges and reservations about these types of cases is the junk settlements and cases brought on behalf of unknown parties.
What's a junk settlement?
Well, that was the phrase used by Mr. Bennett, where I think the plaintiffs in the case, when they're eventually tracked down, they end up just getting a coupon or some settlement for a few dollars when they've actually been injured. So if the goal of the bill is to be able to consolidate cases with known plaintiffs for judicial efficiency, then that's one thing that we might be able to support. If the case is to bring class actions on behalf of unknown parties, that's the challenge, because what we've seen at the federal level is that class action lawsuits that are brought on behalf of unknown parties really do a horrible job of being able to find the injured parties and deliver relief to them. And so if the bill is for identified and known plaintiffs, then that might be something that we can work with the senator on. Otherwise, we would oppose the bill. And if there are amendments that can be made to clarify that, we'd support that at this point.
You haven't looked at the substitute? Just posted it, is that right?
Yes, I've seen the substitute. It's not clear from reading it.
Okay, all right. It's not to go into effect to 2022. Okay. Anybody else would like to speak on the bill, one way or the other?
At this time, Mr. Chair, there are no other hands raised.
Okay. Any discussion at this point?
Mr. Chairman,
yes,
in light of the
Overton.
chair's comment about not going into effect until 2022, and in order to address the chamber's issues, and hopefully we can find a way to substantively address it, I would move that we amend to add a reenactment clause.
Okay, it's been moved that we'd have a reenactment clause and seconded.
Mr. Chair,
Yes, go ahead, Senator Peterson.
I'm going to oppose that motion. We don't know who will be back here next year. We're here right now, and this is a great bill. And you know what? In this moment in time, we're going to pass this bill with this assembly.
Okay. So we got a motion. All in favor of the motion to have a reenactment clause, vote aye. All opposed, no. Oh, I'm sorry. All in favor, say aye if you like the motion. If you don't like the motion, vote no. No. I'm calling it as a negative. Okay, where are we now? Somebody want to make a motion? Been moved and seconded to report the bill. Any discussion? All in favor who want to report the bill as amended, vote aye. All opposed, vote no.
Ayes 9, noes 4.
9-4. The bill is reported. Okay.
Mr. Chairman.
Senator Stewart, do you have?
Mr. Chairman, I have one more with people on the phone.
All right, okay.
Or whatever, on the Zoom.
All right, on Zoom. Who else?
People that aren't being paid to listen. Senate Bill 1468.
1468, certification for victims of qualifying criminal activity. Okay.
Yeah, Mr. Chairman, I believe I have a substitute.
All right.
I move my substitute. Senator Saslaw seconds my substitute.
He's not here, but Louise.
I second.
I've been moved and seconded that the substitute be adopted to Senate Bill 1468. All in favor say aye. Aye. All opposed, no. Motion carries. Okay, Senator Serval, substitute to Senate Bill 1468.
Thank you, Mr. Chairman. So this is a bill that we haven't seen before. So what it has to do with U visas and T visas. So a U visa is available to an undocumented immigrant who is a victim of criminal activity. A T visa is available to somebody who's a victim of human trafficking. And the way they get that visa is they get somebody with law enforcement, typically a victim services coordinator, police officer, somebody like that, to certify that they were a victim of a crime, they were subject to mental or physical abuse, or that they were a human trafficking victim. And once they get that certification, they can then give that to ICE, and then that visa is issued. The problem is and under federal law, they have 6 months. It's a 6-month application process. But sometimes the law enforcement agency doesn't have a person designated to receive it, and sometimes they don't turn it around quickly, and sometimes if they turn it down, they don't give an explanation. So basically what the bill does is it requires every law enforcement agency in Virginia to designate a person on staff to receive applications for these certifications and to certify forms. It requires them to respond within 120 days as to whether or not the person, to fill out the form, either say yes or no. If they say no, they have to state in writing why they're denying that application. And then if they deny it, on lines 102 to, I think, 123 creates an appeal process where the person can go to circuit court and ask a circuit court to certify that they were a victim in order for them to be able to apply to get that visa. The bill basically incentivizes folks that have immigration problems to cooperate in prosecutions so that we will incentivize people to help, affect, prosecutions of people that are guilty of crimes. And it's been passed, I think, in 10, 12, 15 other states now. There's a few people on the line that testify in support of the bill, and that's what it does.
Okay. Any discussion? Anybody want to speak in favor of the bill?
Xavier Racine, please go ahead.
Thank you, Mr. Chairman. My name is Xavier Racine. I'm a partner at Priele and Racine in Fairfax, Virginia. I've been practicing exclusively immigration law for over 20 years. And in the course of my career, I've seen hundreds of people apply for this visa, and some of them have been truly prejudiced by delays in obtaining law enforcement certification. Some of the effects they've experienced are being ordered removed, deported from the U.S. Some of their children have aged out of the benefits because of delayed law enforcement certification. So I strongly support this bill. I think it'll help provide a structure where law enforcement is accountable, where they have to provide a timely response. And I also think it'll go a long way towards strengthening the trust and the cooperation between law enforcement and the community. Thank you.
Okay, thank you. Next.
Brian Murray, please go ahead.
Hi, my name is Brian Murray. I'm also an immigration attorney. I'm based in Fairfax, Virginia. I speak today in support of Senate Bill 1468. This bill will establish sorely needed guidelines for law enforcement agencies and transparency in the process for victims of serious violent crimes and victims of trafficking to obtain important certifications. Under federal law, certain state and local officials are empowered to certify an immigrant victim's cooperation by completing a simple form. That certification, combined with other evidence, may be submitted to federal immigration officials, who then, the immigration officials then decide whether the individual is deserving of a temporary non-immigrant status, a U or T visa, as has been discussed. These protections are provided as a humanitarian matter, but also it's important to note, it's equally important to know that this is a public safety matter. If immigrants in our communities do not feel safe to work with police and prosecutors when they've been victimized, then criminals simply will not be caught, and our Commonwealth will be less safe. Currently, across Virginia, victims of trafficking and other serious and violent crimes seeking these victim certifications encounter inconsistent and opaque process. Some law enforcement agencies do not have protocols for signing. Others refuse to sign or even review requests altogether. Others are known to arbitrarily deny requests based on their own discretion or their own personal views on immigration. 20 other states already have a bill like this. It's time that Virginia inject statewide standards and clarity to this process.
Okay, thank you very much. Next.
Cynthia L. Guzman, please go ahead.
Hi, my name is Cindy Larios, and I'm an immigration attorney in Fairfax, Virginia, here to support SB 1468. For years, I practiced law in Chicago, Illinois, where I represented survivors of human trafficking and sexual assault. In 2018, Illinois passed the Voices Act, which is similar to the bill being proposed today. The Voices Act was proposed and passed in Illinois, like in Virginia, because victims of these horrific crimes who once cooperated with law enforcement agencies were now being largely ignored. After the Voices Act, lines of communication between victims, advocates, and law enforcement agencies were opened and created opportunities for trainings. Law enforcement agencies used the act as a blueprint to better support and engage immigrant communities in their jurisdictions, and it even created opportunities to reopen cases previously closed due to simple lack of miscommunication based on a lack of language access. I want the same for Virginia. Last week, I received a denial of a certification from a local Virginia Police Department for a victim of domestic violence. When I asked why it was denied, the response I received in an email ended with, "This police department does not offer an explanation for the decision to sign or not to sign a certification. Our victims simply deserve more." Thank you.
Okay, thank you. Next.
Maggie DeBoard, please go ahead.
Good evening. I want to preface my remarks here that I am absolutely in favor of the concept of what this bill is trying to do. I have a large immigrant community in Herndon, and representative of the Virginia Chiefs, I want to make clear that we do support this process. We don't feel this bill meets that because in addition to the qualifying crime, there are two additional factors that have to be made when deciding to sign the certification. And in my agency, I'm the one who signs them, for example. And it's, did they cooperate with the investigation and have they committed any other concerning crimes? The concern is here 120 days may not be enough to know if they've really fully cooperated. The problem with this with the legislation, the way the form is laid out right now, I get that form on my desk. I have to do the research, the background to make sure that they did cooperate, that the crime was qualifying. But if I sign that thing before we've gotten very far in the prosecution, at any point in time, that person can withdraw the cooperation. We want cooperation. We want to make sure that it works, but we want the law to be functional so that we can balance both sides. Lastly, I would like to say that the Virginia Chiefs absolutely support policy that would ensure that agencies comply with filling these forms out and that they have policies in place so the public knows exactly how they're supposed to process these forms.
Do you have a suggested amendment or something? I mean, would you like to talk with legislative services about improving the bill?
I would love to work with them on behalf of the Virginia Chiefs because I think we can come to a compromise and come to a good place because we do support the concept of ensuring these forms are at least processed. The problem with the forms now, there's nowhere on those forms for me to write my denial there. There's no process for me to write it. It's either sign it or don't. And that leaves us in a very difficult spot. I can't falsify a form and put that information on there. Cannot put my name on a form that I cannot completely support at that point.
Okay, Charles, could you check with her and consult with her and Kristen?
Mr. Chairman.
See what improvements might be necessary. Yeah, Senator Serval.
Thank you, Mr. Chairman. I mean, I'm really used to working with Chief DeBoard. She's a pleasure to work with, and I gave a draft of this to her before. I'm pretty sure that if circumstances change after a certification is made, you're allowed to communicate that to ICE to see if they will change their visa status. But I'm happy to continue to work with her through this process to confirm that she's able to do what she wants to do. I made some changes to this already in response to her feedback, and so happy to keep working.
I might not have seen all of those. I apologize. I will be glad to work with you and take another look at it because we do support the concept, absolutely.
That'd be great. Okay, thank you very much. Who else? Is another person wants to speak for the bill?
Sandoval Motionberg.
Good evening, Mr. Chairman. Simon Sandoval Motionberg, Legal Director of the Immigrant Advocacy Program at the Legal Aid Justice Center. In response to Chief DeBoard's comments, I want to point out that the substitute at lines 94 through 96 absolutely provides that once a certification is issued, it can always be withdrawn if the victim unreasonably refuses to continue to assist in investigation. So that concern is already baked into the bill, and there's already a proviso that allows for certifications to be withdrawn if someone stops cooperating. This is the most important, the U visa is the most important tool that law enforcement has to build trust within the immigrant community. They've been given this tool by federal law, but up till now, there's been no state guidance or guardrails whatsoever on how to use it. This bill would provide that guidance. The timelines are critically important, and the ability to seek review in circuit court is also critically important, because without the ability to seek circuit court review, the timelines are meaningless. And so for all of those reasons, Legal Aid Justice Center supports the bill, and we do believe that in its current form, the substitute adequately addresses the concerns that the chief raised.
Okay, anybody else want to speak on the bill or against the bill? One way or the other?
At this time, there are no other hands raised.
Okay, is we ready for a motion?
Move to report, Boysko seconds.
Move to report the, is it substitute or as amended?
Yes.
The bill.
Mr. Chair.
Yes, Charles?
I don't mean to derail the proceedings, but I'm having a large technical difficulties over here, so the substitute is not currently posted online. It has been described in detail by Senator Serval and by the witnesses as to what it does, but I was just alerting you that right now it is not posted online. It is a substitute, and it has been described, and I know the committee has acted before.
Why don't we do this? Why don't we wait till Monday? We've heard the testimony, and you can look at the substitute, and Senator Serval can check with the Chief DeBoard, perhaps between now and Monday, and staff can consult with Serval to make sure it is a substitute that you want. Is that okay? We'll hold off till Monday. We've heard the testimony. We don't need to hear any more testimony. We'll deal with it first thing Monday morning. Is that okay? All right, without objection, that's what we'll do. Okay, thank you. Senator Serval, 1446. You sure you want to hear that today or put it off? It's complicated, having to do with telling doctors what they can and cannot
I know there's two people online waiting, or actually probably more than that, waiting to speak to it, but I believe none of them are, I think they're all retained government relations professionals. So,
all right, so Senate Bill 1446, yeah, well paid. Well, that's good, I'm sure. All right, that's the bill we heard last year. What happened last year? I can't remember.
No, it was in Senator Lucas's subcommittee last year, Mr. Chairman. It wasn't in this committee.
Okay, we'll look at that Monday morning.
It was sent off to be studied, which we tried.
Okay, maybe, I don't know if we arrive at any kind of agreement or not, but anyway, this bill will be taken up Monday along with the substitute for Senate Bill 1468. So 1446 and 1468, first thing Monday morning. Senator Stewart also has a bill that we haven't dealt with, but he's not here. Is there,
He told me I was able to present his bill if he wanted me to, but I think he'd be happy if we just continued it to.
okay, we'll do it Monday morning.
Look, you can send all mine up there too. I'll just put mine on Stanley.
Yeah, Stanley, we got a bunch of bills for Senator Stanley.
Yeah, but they're easy, but I'm not doing them tonight. 1426, 1105.
Yeah, they'll take
1415.
half a Monday morning, however, probably.
It'll be Bill Stanley Day. We can call it that. How's that?
Yeah, well, tell you what, let's make
Cameron
it.
Stanley Day.
See if you can't fix those bills. Well, all your bills are too daggone complicated, Stanley.
Wow.
Yeah.
Love you too, Johnny.
Malpractice, protective orders, restitution. All right, okay.
They're all fixed.
Now, does anybody have anything else they absolutely have to do right now?
Mr. Chairman,
Yes, Senator Morrissey.
I have Senate Bill 1306, and I thought maybe we could come back at 9:30 this evening after dinner and take that up with others.
How about 1 o'clock tonight? 13. What's the number? 13.
1306, assault and battery. It's usual suspect. It's been around for a
Didn't
while.
we deal with that?
Serval birthed it last year. It's still percolating.
Assaulting police officer. Is that it? I thought I have checked. I checked it off. Is it something we did? We didn't do that today. No, we haven't done that. Do you want to talk about it, or just wait till Monday morning?
Mr. Chairman, I can do it Monday, and Senator McClellan has a bill that I think she wants to present.
We've already took care of her, didn't we?
No, you didn't.
Oh.
Mr. Chair, I have 1315. I had people that
Okay.
were on the line. I don't know if they're still there. If they
All right, let's see if anybody's here. Senate Bill 1315, Senator McClellan, criminal proceedings, consideration of mental condition, intellectual and developmental disabilities.
All right, thank you, Mr. Chair. This bill mitigates the challenges faced by people with mental illness or intellectual and developmental disabilities in the criminal justice process. It does three things. It requires a judge to consider a defendant's disability at bail and sentence stages. It adds training for court-appointed counsel to help them understand the unique considerations representing people with mental health conditions and intellectual and developmental disabilities. And it updates Virginia's evidentiary rules to ensure defendants can put on evidence, including expert clinical testimony about how their mental health condition or disability might have impacted their mental state at the time of the alleged offense. I have a substitute that addresses some concerns that had been raised by, I think, the Commonwealth's attorneys.
Okay. What's the substitute do?
Well, what I just described is the substitute. So the context for the problem here is that people with disabilities or who are more likely to intersect with the criminal justice system have cognitive challenges and gaps in the social services that raise their risk of police contact significantly. And navigating the criminal justice system is extremely hard for people with disabilities and mental health conditions who face significant challenges in understanding their rights and assisting in their defense. Unfortunately, court-appointed counsel are not trained in disability and mental health specific issues, which they need to be to provide clients with a vigorous defense. This is particularly true with individuals on the spectrum. And Virginia does not adequately weigh mental condition-related concerns and explicitly bars consideration of them in the guilt phase of trials. And while we made strides last year in allowing for deferred disposition in some cases, the bill we passed last year, Senate Bill 133, only applied to a narrow category of defendants and required them to waive their trial rights. And so there are a number of people who support the bill, and hopefully they're still here, but this is the result of work and research done by the UVA Law, State and Local Government Clinic, ARC of Virginia, and Autism Votes.
Okay, this would be a significant change in the criminal justice system, right?
It basically, as I understand, Mr. Chair, I think this bill creates the diminished capacities defense in Virginia law.
Not exactly. It allows evidence of a disability or mental health.
I'm not going to disagree.
Okay. Well, it doesn't really create a defense so much as it says you can provide evidence of it to mitigate.
Well, not guilty by reason of insanity, the standard is so high in Virginia.
Right.
This creates some middle ground that I think reflects the reality of the people that I see in court frequently.
Yes.
Well, it does, right now, you can bring in mitigation extenuation at sentencing, but not at the guilt phase.
And
right?
That's right. That's right.
Mr. Chairman,
Yeah, Senator Morsi.
question for perhaps counsel. First of all, because there is no middle ground between not guilty and not guilty by reason of insanity, there is absolutely currently no middle ground so that you can introduce evidence during the trial of the defendant's mental defalcations, for lack of a better word. I love that portion of the bill that allows you to do that, but I'm trying to wrap my head around section 19.2, 271.6, subsection B that says, quote, nothing in this section shall be construed to affect the requirements for a defense of insanity pursuant to Chapter 11. So my question for counsel is this. Does this bill do what has been long overdue, and that is allow a defendant to introduce evidence of his mental condition without going the full measure to presenting an insanity defense?
The answer is yes.
The problem I have, and I know something about the criminal justice system, is I don't know how you do this at the finding of guilt stage. You do it a lot at sentencing. I don't know how you do it at the guilt stage. Does somebody want to speak? Some people out there, give everybody at least a minute to say what they want to say. Yeah, there are a bunch of people here.
This is huge. Oh, sorry.
This is a huge change in the criminal justice system. We don't have 10 hours to deal with it, but I would like to at least have, since people are already there, if you don't mind, say who you are and briefly what your position is.
Gayleen Knoyton, please go ahead.
My name is Gayleen Knoyton. I'm with the Virginia State Conference NAA. We see a lot of cases of with mental health issues that get into the criminal justice system that have a choice on how they need to plead. So we strongly support this bill.
Okay, next.
Nate Green, please go ahead.
Thank you, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, speaking on behalf of Virginia's Association of Commonwealth Attorneys. We are opposed, but our opposition is very specific. I don't have the substitute, but I believe I've been provided with some information about it. What we are opposed to is not the consideration of ID or DD as defined in 37.2100, but rather to the inclusion of anything that is in the DSM. The DSM-5 right now has just been expanded to include mental disorders like internet gaming disorder, disruptive mood dysregulation disorder that says that if this is characterized by severe and recurrent temper outbursts that are grossly out of proportion in the intensity or the duration to the situation. It includes conduct disorder. All of these disorders are now what we are tying Virginia law to, and these become evidence that will be presented. We also, the other area that we do oppose is the fact that in insanity cases, when the defendant is going to raise an insanity defense, the law allows for the Commonwealth to have an independent or an expert do an evaluation of that individual so that we could have at least dueling experts. At the way the bill is written at this time, the defendant is the only one that is in possession of the evidence of his mental condition. Only his expert is allowed to examine him, and only his expert would be the one that would testify. There's no element for the Commonwealth to test that expert in any way. For those reasons, Your Honor, we are opposed to expanding the diminished or bringing diminished capacity in, and most importantly, tying it to an ever-evolving DSM that has a wide range of mental disorders that it identifies, to include pedophilia and the other ones I've mentioned. Thank you.
I have a question myself, and that is, I don't know how you do this at the finding of guilt stage. I see out in the sentencing stage, you can bring in all sorts of stuff.
Mr. Chairman.
I'm not sure mechanically how you do it at the finding of guilt stage. Yes, Senator McClellan.
Yeah, first, I want to respond directly to what the gentleman said about the definition. We specifically, based on VACA's concerns in this substitute, changed the definition of mental illness in the code to be much more limited, or in this bill, to be much more limited than what is in DSM, specifically around lines 154 to 157. We specifically say that this would be related to a mental illness as defined in 37.2-100, or for the mental illness capacity, or a developmental disability or intellectual disability is defined in 37.2-100. To your point, though, at the guilt or innocence phase, you have to be able to determine whether, in a lot of cases, a defendant had the requisite mens rea to meet all of the requirements of that crime. And for some people who have autism in particular, and this is particularly concerning with people who have autism or who are on the spectrum, who often just don't have the intellectual understanding of what certain behavior is and are incapable of having the required mens rea, but they're not able to provide that evidence. And they're not insane, but they don't have the mens rea. And so under current Virginia law, there is no way at all for that to be considered at the guilt or innocence phase. This provides a mechanism to provide that evidence.
All right, go ahead.
Mr. Chairman,
Mr.
Chairman, it's Steve. Let me add something, please. The Senator McClellan correctly, I think, described the amendment that she is proposing, but left off. Hold on, it just left. That she's also including autism spectrum disorder as defined in the most recent edition of the DSM. And so it would be mental illness as defined in the code, a developmental disability or intellectual disability as defined in the code, or autism spectrum disorder as defined in the DSM. That would be the new amended definition.
Mr. Chairman?
Yeah, let's go ahead and hear everybody else first.
Oh, I thought he was finished.
Go ahead. We got some other people. See what they have to say.
Brad Haywood, please go ahead.
Hi, Brad Haywood with Justice Forward, Virginia. We do support this bill. I just wanted to clarify that this does not create the defense of diminished capacity. With diminished capacity as a defense, what that means is that someone is categorically unable to form certain mental states. This isn't what that does. What this does, it allows people to introduce evidence to demonstrate that in a given case that they did not have the mental state that is alleged of them. So it's not that that person can't form mental states in general. That would be insanity, or it would be the diminished capacity defense. It's that in this case, because of the way their brain works, whether it's intellectual disability, developmental disability, serious mental illness, they did not have the mental state that is alleged of them. And the application is actually very narrow. Not only did the amendment to require serious mental illness according to the code take away basically the disorders that Mr. Green mentioned, but also it really just isn't going to, it's not going to apply that in that many types of instances. I'll give an example of one where it might, and this could be enlightening to the committee. On a case with somebody who's schizophrenic, who's homeless, and it's a very cold night, and he's walking down the street in a retail area. He is disordered, his thinking isn't clear, he sees a door, he goes into the door, you know, he knows he's trespassing, but it's a retail store, and he ends up there and he's caught in there. He's charged with burglary, and burglary requires the intent to steal. Well, you might want to know what was going on in his head in order to explain that actually he didn't have an intent to steal. He just didn't know where else he could sleep. So that is what this bill would allow, and people ought to be able to introduce competent evidence to demonstrate what their culpability is. That is an essential part of due process. That's what this bill would allow, and that's why we support it.
What's your response to the Commonwealth attorney saying like in insanity, you got to notice ahead of time, and they get a chance to have a psychiatrist also. What is your response to them having somebody else look at their mental condition? The defendant can raise that issue. And we're talking about finding of guilty now, not sentencing. So what is your response to the Commonwealth attorneys not having the ability to get into this issue?
Notice.
I think there's a 60-day notice required at this juncture. Once that happens, then the Commonwealth could subpoena medical records, mental health records, could solicit their own expert to come to court to testify about the effect of certain mental illness. So they would be adequately prepared. I think 2 months is more than enough time to get ready for it.
Okay.
Mr. Chairman.
Next person. Let's go here. Next person.
Brian Kilmer, please go ahead.
Brian Kelmar. I'm with Legal Reform for Intellectually and Developmentally Disabled, and I represent hundreds of families here in Virginia and across the nation for exactly who this bill applies to. I have an autistic son who's got caught up in the system. As the judge said, unfortunately, Virginia doesn't recognize the disability. Our most vulnerable population of the developmentally disabled and mental illness should be allowed under the quality of the law as to present their evidence and their particular situation as under the American Disabilities Act. Each person should have the opportunity to hear all information that's relative to this person's particular case throughout the entire criminal justice system and not just at the sentencing. We strongly support this bill.
Okay, next.
Eugene Oliver, please go ahead.
Thank you, Mr. Chair. My name is Eugene Oliver. I'm president of the Virginia Association of Criminal Defense Lawyers, and we support this bill. To address one of the concerns that was brought up about how this would actually take place at the guilt stage, simply put, this is an expert or other testimony to address mens rea. It'd have to be admissible evidence. Certainly, while this bill, I think, is including expert, most of the judges I know would require expert testimony in order to establish those facts. Similarly, the notice provisions would address the concerns of the Commonwealth. They would have the opportunity to get their own witnesses. We believe that this would be an important reform. Virginia's rules on the admissibility of mental health evidence is very restrictive, and certainly this would go to leveling the playing field and getting in the appropriate evidence and allowing Virginia's rules of evidence to catch up with where mental health is today. And I ask for your support.
Next.
Kyle McCoy.
Good evening, Mr. Chairman. My name is Kyle McGoey, and I'm a student with UVA Law's Policy Clinic under the supervision of Professor Andy Block. Our team worked closely with Senator McClellan's office to help develop SB 13, and I want to quickly highlight two of its benefits. I want to disclaim today that the views I express are my own and not those of UVA or UVA Law. First, the bill ensures that court-appointed attorneys receive the specialized training necessary to effectively represent clients with these unique and challenging conditions. Many of the people who find themselves caught up in Virginia's criminal justice system have these conditions, and SB 1315 ensures they will have a skilled and vigorous defense. Second, the bill allows a court to consider evidence of a defendant's mental illness or disability when the condition impacts their ability to form the mens rea for the crime charged. Though this provision represents a change to Virginia's rules of evidence, it is not a new concept and is consistent with recommendations of the Model Penal Code, the American Bar Association, and the practices of over half the states and the federal court system. For all these reasons and those offered by others, I urge you to support this bill.
Okay, next. Anybody else?
Anna Mendez.
Good evening. My name is Anna Mendez. I am a fellow at the University of Virginia, where I study the decriminalization of mental illness. I'm also the executive director of Partner for Mental Health in Charlottesville and the board president of Mental Health America of Virginia. This bill better aligns Virginia's criminal procedure with the clinical reality of mental illness. Equity demands that you pass this bill as submitted. This bill will ensure that all defendants in Virginia with mental illness, especially Black and Brown Virginians who continue to experience systemic racism, will have the opportunity to present all evidence relevant to their defense at trial. Thank you very much, and please pass this bill.
Thank you very much. Next.
Catherine Zagorski.
Catherine?
Good evening, Chairman and Senate Judiciary Committee. My name is Catherine Zagorski. I'm with the Virginia Indigent Defense Commission. This is an important bill, and I'm happy to answer any questions that anyone in the committee may have about it.
Let me ask you, these kind of cases, are many of them very serious or more misdemeanor type cases?
Serious, both.
I think that
Yeah.
this would cover both misdemeanors and felonies.
Well, I mean, as a practical matter, the people, and I've represented people in this category too, the ones I've had are fairly minor situations.
Mr. Chair, I've represented people that are in this category charged with pretty serious felonies.
Okay. Yeah, I'd like to hear some factual situations. Can somebody on the panel tell me, so give me some examples of cases? All right, next, who go ahead. Go ahead.
Would you like an example?
Yeah, give me an example.
Well, this wasn't allowed to be introduced, but currently I have a case on appeal where a young man with no criminal convictions was convicted of aggravated malicious wounding. He was on the autism spectrum disorder, and that's a case where I think it could have been introduced with this bill, but it wasn't able to be introduced. And he ended up with a life sentence, which was the high end of the guidelines was 13 years, and he ended up with life. And I think that with this bill, if defense counsel was able to introduce that evidence, it would just simply let the fact finder take into account and consideration his autism spectrum disorder and decide and to take that into account whether or not he could form this the malicious intent.
Well, that's good. I appreciate that. All right, who else want to say something?
Maria Yankovitz.
Good evening, Chairman, members of Judiciary. Maria Jankowski with the Virginia Indigent Defense Commission. I signed up to speak to this only if there were any questions related to the expanded training requirements of the bill. We are very able to meet these new requirements. They would not cost us any, and we could accommodate this portion of the bill easily.
How about training judges?
That's not my job.
That's where the big problem is, I think, from my experience. Anyway. Okay.
Problem with judges?
Mr. Chair, the Supreme Court has recently, in the last couple of years, they've done a pretty good job of providing training on mental health. And actually in their indigent defense training, they provided some mental health training as well. So
okay,
things are going in the right direction there.
All right. I've had some experience in this area too, and it wasn't very good. Okay. Anybody else have anything to say?
Tanya Milling, please go ahead.
Yes, hi. I'm Tanya Milling with the ARC of Virginia. Thank you, Mr. Chair and members of the committee. We greatly appreciate Senator McClellan for bringing this legislation forward. We support the amendments in the substitute for recognizing a person's intellectual and developmental disability or mental health condition. This recognition is critically important during the criminal justice proceedings. Too often, people with intellectual and developmental disabilities and or mental health conditions, particularly Black, Indigenous, and other individuals of color, become trapped in the criminal justice system because the system does not recognize how these things affect that person's interactions with the justice system. So we hope you will support this bill. Thank you.
Thank you.
Mr. Chairman.
Anybody else? Yes.
Is Mr. Benjamin still there?
Yeah, he's there.
Mr. Benjamin, you know as well as anybody that there's a huge chasm between not guilty and not guilty due to insanity. Do you believe that this bill allows for a defense attorney to cover that spectrum from mental illness, ID, autism, and address those issues that you see every day where the defendant doesn't possess the requisite mens rea to commit the crime, but the judge doesn't allow you to get that evidence in because it doesn't go the full measure to insanity? Does this cover those practical problems?
It does. There is no question about it that this bill has been necessary for decades of Virginia jurisprudence, and this bill cures a huge chasm where people who would not be guilty of the offense they are charged with would have the opportunity to present relevant and reliable evidence of their innocence. This bill is absolutely necessary. It does what the patron explains.
Hi, Mr. Chairman, two final points. You seem to be somewhat concerned that the judges need to be trained. They don't need to be trained any more in this than any other dueling expert between the prosecutor and the defense in any other discipline. Second, I agree with the prosecutor that they should get all of the advance notice on what the defense intends to introduce. And lastly, allowing this evidence in just at sentencing is, quite frankly, missing the entire game. By that time, the person has been found guilty, and that person was prevented from introducing evidence of mental illness, ID, or autism spectrum. I have a motion.
Wait, before you...
Go ahead.
Mr. Chair, there is a technical amendment that
Okay.
Mr. Benjamin alluded to, but it wasn't technically in the bill yet.
That is correct, Mr. Chairman. If you will, there are three amendments. The first I alluded to on line 157, insert a subsection C that would read autism spectrum disorder as defined in the most recent edition of the DSM. The next amendment would be on line 151. After the word evidence, insert the words offered by the defendant. And on line 152, after the word relevant, add, comma, is not evidence concerning an ultimate issue of fact, comma.
All right, is there
I'll
a
move the
motion?
amendments.
All right, it's been moved.
Second.
And seconded that these amendments to the substitute be adopted. All in favor say aye. Aye. All opposed, no. Motion carries. Okay, does anybody else have anything else they want to say?
Mr. Chairman, you had asked for a specific example, and I can provide that if you wish.
No. We can
Okay.
talk. We can talk. I've got some examples too I'd like to talk to you about. I think you're absolutely right. All right, so is there a motion that the substitute as amended
Move to report, Sasslaw,
be
seconds.
reported
And re-referred to finance.
and re-referred to finance?
And what he said.
All right, all in favor of the motion to report the substitute as amended and re-refer to finance, vote aye. All opposed, vote no.
Ayes 8, noes 3.
Mr. Chairman.
Yes.
Thank you. Mr. Quagliato tells me that my substitute on the immigration certification cooperation bill is up online now, and so I think 1468. So I think we could vote that now if you like.
Okay. All right, you got a motion?
I move to report. Senator Boysko seconds.
Is
Senate
there-
Bill 1468.
All right, any discussion? All in favor of the motion to report the substitute to Senate Bill 1468, vote aye. All opposed, no.
Ayes 8, noes 3.
Going back to 1315, I think Senator Frivola had Senate Bill 1383, which is similar, if not identical. Senator McClellan, does she want to roll hers into yours?
I think we've already done that, Mr.
We
Chair.
did that? Okay, we've already done that. All right, thank you. Okay. All right, what else we need to do?
I mean, Mr. Chairman, we could go back to my litigation cooperation bill or Senator Stewart's search warrant bill if you want to try and get some done. General laws is still going across the hallway here.
Well, do you have the authority to, on Senator Stewart's bill?
Yes, I do. He told me he'd be happy for me to present it.
Okay, what do you want to do? Present his bill, Senate Bill 1475, execution of search warrants. What does the bill do?
Thank you, Mr. Chairman. Hold on, let me pull that up. Which number is it?
1475.
Okay.
He said it was fairly simple.
Yeah, it's mainly a cleanup bill from last session. Basically, this cleans up some of the search warrant provisions that we adopted
Okay.
in Senate Bill 5030 last year that I worked on with Senator lock. And the chiefs of police and the state police had some things that they had hoped we gotten done during the last process, but they didn't get done. So I'll walk you through them real quick.
Okay, very quickly. 1475.
Okay. First of all, Mr. Chairman, on line 80, on line 90, there was language in there that says that when a police officer serves a search warrant, they have to be in uniform and they have to announce themselves to everybody in the premises. The Virginia State Police came to us afterwards and pointed out that they frequently serve search warrants on businesses wearing a suit, like to get, for example, a surveillance video or something, and they'd really prefer not to have to yell to everybody at the McDonald's, "We're here to serve a search warrant," and so this limits that requirement to a private residence and not to businesses.
Okay.
That's what the edit on line 90 does.
Okay.
Line 96 requires the law enforcement officer to hand the affidavit with the search warrant to the person whose residence it's at, and not just the warrant itself. So they get the warrant and the affidavit, which is a good idea, I think, and also the same things on line 99. Then it gets a little more complicated after that. Lines 100 through 109, instead of, this has to do with serving of warrants in the daytime, defines daytime as being between 6 a.m. and 9 p.m. And I can tell you, Mr. Chairman, that there's going to be more discussion with that as this bill moves through the process, because I've been talking with the House sponsor. I'm not sure how happy she is about that, but the rest of this bill is pretty good. Let me see. Then on lines, let's see, 104, it says that that they don't have to go get a judge to sign off a warrant if the warrant is requested once the police are already inside of somebody's house. So it's only, you only have to go to the judge if you request the warrant before you go to the house. And then number 4 says you don't have to go to a judge if the item you're seeking to search is already in the officer's possession. So, for example, sometimes police officers will come into possession of an item and they don't want to go inside the item without getting a search warrant. And so this just says if they've already got the item in their hand, you know, like it could be a film canister, it could be a backpack, it could be that they can just get that warrant from a magistrate. That's what I believe that one does. And then lines 108 to 109 simply says that if the search starts before 9 p.m., it can continue after 9 p.m. Then lines 111 to 112 make it a little easier to get the warrant from a magistrate instead of a judge. Line 116 to 117 basically only apply the exclusionary rule if there's bad faith or if the defendant's rights were prejudiced. I actually object to that amendment, and I'm going to move that we strike the amendment on lines 116 to 117. And Senator Boysko seconds my amendment.
Okay. Mr. Chairman.
Go ahead. Who's this?
Can I ask the substitute patron, has the patron agreed to your carving up of his bill? He said you can do this?
I told him what I was going to do to his bill, and he said, yeah, I figured you'd do that. But he doesn't agree with that amendment.
Mr. Chairman.
But I also could tell the Senator Stanley that Senator Stewart and I have talked extensively about this bill before it was filed and after it was filed, but he doesn't agree with that amendment.
I agree with it.
Mr. Chairman.
Yeah, Senators. Yeah, Steve.
There are some good aspects to this bill, and there are some not good aspects to this bill. It can be put into a good form, and I would suggest that it be carried over so that I can make these suggestions to Senator Stewart.
All right, let's do that. Okay, without objection, we put it by till Monday. You make those suggestions.
Yes.
We don't want to create the good faith exception. It's already in federal law. It's a terrible idea. Yeah. Senator Morrissey.
Given all the proxies that Senator Serville has in his pocket, is it necessary that anybody be in this room with the exception of Senator Serville?
No, I think that's it. He can sit right here and everybody else can leave. And okay. But seriously, no, without objection, we'll put this off to Monday. Steve, you talk to everybody and fix it. I think it's a good bill otherwise. But we don't want to add a good faith exception. In fact, I never did like it. Okay. Anybody else have anything else they'd like to do tonight? Senator Stanley, you prepared to spend all day Monday morning?
I cannot wait.
I can.
Because you know why I can't wait, Mr. Chairman? Because that means I'm gone here earlier tonight. So, absolutely. Looking forward to it.
Well, we got a big day, I think, Monday anyway.
Mr.
Yes,
Chairman.
sir.
Yes.
I'll make it work you out.
Mr. Chairman, I move that we give combat pay to all the clerk staff who stuck it out with us tonight.
I think they've done a fantastic job. Let's give them a round of applause. So you guys have been fantastic. Last winter we were here at 11 o'clock, weren't we? A few times. We promised not to do that this year. Is there anything else that needs to be done? It's now almost 8 o'clock, 5 minutes to 8. Okay, if not, the